Supplementary list, fresh submission item number 1.
Wait, please, the lordships. The same matter matters. Lordship on 5-1 admitted the appeal on the following questions matters. Lordship will remember that Panchanama, there was nothing incriminating material found. And there was invocation of jurisdiction under section 153A1. And they found a city, same, and it may be tagged. Subsequent years are all same.
All right.
This was for the year 3-4, now 4-5 to 8-9.
All right.
They are all same, identical. These orders, assessment orders, first appeal order, second appeal orders, all are copy paste.
All right. Your Lordship, in this case, the tribunal has remanded because he has not appeared even before the. Let's see, that day will decide.
Yes.
Same order.
In fact, it is covered by your Lordship's order that Kabul Chawla and Mita Gudgud.
All right.
Balance.
Item number 2.
Same.
2 to 5.
Supplementary
Supplementary list, item
1
number
to 5 matters.
Item number 6.
None appears.
Supplementary list, item number 7.
My lord, the river embankment as shown in the record of right is encroached by the OP number 5. So, my lord, people are getting, my lord, hindrances to for the ingress and
Representation.
Annexure 4, my lord. Annexure 4, page 20.
There are two annexure representations, sir. 4 and 5.
4 and 5. So, I appropriate authority.
Is the Tahsildar.
No, 4 is to the Administrator Urban Cooperative Bank, sir. What is this? 1 minute, something wrong. 1437, right? Annexure 4 is some representation to the bank.
No, my lord, this is my, perhaps, it is my annexure to sub-collector.
Sub-collector Kendrapada, annexure 4.
4. Page 20.
Something wrong, sir.
There is also no acknowledgement of receipt.
No, receipt, yes, right side.
1577. All right. The petitioner's representation bracket annexure 4 shall be examined by the Tahsildar.
Tahsildar, my lord. OP number.
After notice the petitioner
number
and
3.
opposite party number 5 and giving them a hearing. The reasoned order shall be passed not later than 3rd April. Committed party is not later than 10. The court clarifies it is not expressed in you.
Right.
Item number 8.
May I please, your lordship. The issue relating to coal bearing acquisition act, the MCL invited a notification under section 4 of the act, acquire entire project land of the petitioner, petitioner village. Now, that is in 2019, Now in 2022, they reduced they have to acquire some lands, because this, we are submitting if the part of the land was acquired, then other it cannot be utilized.
No, is it PIL or is it your own?
He is a PIL on behalf of villages, is filed, and he filed objection also to the MCL coal fleet to acquire.
But your own land is getting acquired.
My land and villages land. Total, your lordship kindly has the land as its schedule has been mentioned.
But if it's your land, you should file not a PIL, sir.
Your lordship kindly.
They are saying that the land is not being acquired. They had said this is about 100 acres. They have now taken some 50 acres. So
Annexure 13, page 13, your lordship kindly have seen.
That is what.
Lord, our village, lordship, serial number 5 is our village, your lordships. The acquired to be land is total hectares, 233 side column is full, your lordships. Lord, they have already they have made notification, section 4, your lordships. And then your lordship, annexure 2, they modified, your lordship, kindly relevant page is your lordship, kindly on to page 17, your lordships. Serial number, same serial number. They have taken the part land. So we made an objection that the part land.
Representation dated 22nd October 2021.
And subsequent thereafter also, your lordships. I annexed all the postals.
Should be examined by the MCL.
By MCL, your lordship, MCL OP number, your lordship.
5 by the project officer. Or,
Opinion number 2, my lord.
or by
My lord,
the,
before, my
by
lord,
the Mahanadi Coalfields Limited,
Sorry.
bracket opposite party number 2. And after notice to petitioners leaving the hearing, the reasoned order shall be passed thereon not later than 10th April.
lordship, my lord, only I am saying
And
before.
communicated to the petitioners within a week thereafter.
Oblige your lordship. Lord, I am saying that before passing the final notification, my lord. This must be because we are saying that villagers land, my lord, they have to part of their acquiring, my
I
lord.
don't know what this procedure is, sir. If you have to come in a PIL like this, you're not going to they're not going to follow all this procedure.
Your lordship, opportunity of hearing, your lordship.
Yes, yes.
Yeah.
Yes, sir.
Item number 9.
Sorry, Lordship, sorry, item 6, Lordship. The issue is already been decided in other matter, Lordship, so no.
All right.
Non-appearance.
All right. Dismissed as infractions. 6. All right.
Item number 9.
My lord, item number 9, on behalf of Mr. Roy, I pray for 2 weeks time. Mr. Roy is not well today, my lord.
All right. Counsel to petitioners to be under.
My lord, in this case, counter is ready since 2014. Indefinitely, it has not been filed. We'll be filing.
All right. 23rd August.
Item number 10.
Grateful, my lord.
Item number 10.
And none appeals dismissed.
Supplementary item 11.
Wait, please, your lordships. My lords, here, my lords, provisional assessment for the period 12-13 was completed. 12-13 was completed by the annexer 3 at page 22. Provisional assessment, my lords, which was served in 2019 March. Then, my lords, against those, this is for the period 12-13, another is item 46, my lords, 11-12. Then I filed appeals as per the direction of the Honorable Court, this Honorable Court. My lord, the appellate authority under Annexer 5 at page 29, what he did, he set aside, against which I moved before the tribunal. Now the tribunal, by order dated under Annexer, Annexer?
6.
6. Yes, 6 and 6A allowed me appeals, and lordship will be pleased to see that, of course, not the relevant. I will take your lordships to the observation made by the tribunal at page 60, para 7.2. Then I'll take your lordships to another finding of the tribunal at page 67, para 9, where the finding is given by the tribunal, para
Okay.
9.5.
Because you went before the
Yes,
CLT,
yes,
ABC.
yes. Now, my lords, then I applied for refund.
Now
They-
you want you to again
They
produce
rejected.
books. Ah.
Yes. Then I approached before this Honorable Court. This Honorable Court, the moment I filed, they came to know that a writ petition has been filed against them. So they immediately withdrew that letter rejecting. Now, my lords,
They ask you to produce books of accounts.
now, my lords,
They're asking you to produce books of accounts.
no, books of accounts as per the direction of this Honorable Court, I produced. And this Honorable Court said that you produce which will facilitate the refund. Now the refund has also been given.
Hmm.
Thereafter, my lords, an arm twisting method has been adopted. That is Annexer 1. Now, without in form VAT form 307, notice has been issued
For the same period.
for the same period. That is 12-13, 11-12. This is a textbook example of arm twisting. Textbook example, my lords.
All right. This notice, you accept this
Because of my lord's order, this notice has been issued.
notice.
That
We
is-
asked you to, we asked you to harass them, so you're harassing them.
Let that be stay of further proceeding, my lords.
Replies within 8 weeks to join for the next date. Till the next date of hearing, no further steps will be taken pursuant to the notice dated 18 November 2022. Bracket Annexure 1.
for the period, my lord, 11, 12.
No, that's okay. Annexure 1 will
Yes,
take care of it.
yes. Sorry.
List on 28th August.
Item 46, my lord, sir, for the separate assessment here.
Same order.
After 4 months, my lord, 2023 will go.
Right.
Obliged,
28th
my lord.
August.
Item number 12.
May I please your lordship? My lord, as per synopsis, my lord, I pray for a direction to carry out amendment in the GSTR 1. So the notice may issue to the opposite parties.
All right. Notice.
Private opposite party, my lord, 7 and 8.
Okay. Notice will now go to the remaining opposite parties 7 and 8 returnable. On the next date, tracking report will be placed on record. Replies be filed within 8 weeks of service of notice. The joint of 24th.
My lord,
24th
I'm appearing
August.
from opposite party number 2456. I
All
can
right.
accept the notice.
All right. He
My lord,
accepts for
short.
purposes.
May I pray, my lord? Or that, my
9. Sorry. It'll all take time. sir.
mine. Obliged.
Item number 13.
13 May, please, your lordship. Now, here the petitioner challenged the demand notice issued by the opposite party member for directing for deposit the shortfall amount of MGQ. Lordship may permit me to withdraw the application with liberty to file an appeal before the appellate.
Council petitioner seeks leave to withdraw the present petition with liberty to approach the commissioner, excise commissioner in accordance with law. This post of is withdrawn with liberty is paid for if the application is an appeal or
Appeal.
Appeal, your lordship.
appeal is filed before the commissioner. Not later than 1st March, accompanied by an application for condemnation of delay. Explaining the delay on account of the pendency of the present petition will be considered in accordance with law by the appellate authority. The court clarifies it is not expressed in the matter. Originals will be returned subject to substitution by attested photocopies.
Obliged, your lordship.
Item number 14.
None appears deceased.
Item number 15.
15 not present.
Not pressed. Dismisses.
Item number 16.
Item number 16, my lord, the cost title of the appeal memo needs to be amended. As after filing the present appeal memo, Tata Power Central Odisha Distribution Limited has to cover the charges.
What is the date they took over, sir? Must be much earlier.
Yes, my lord. The Tata Power has taken over the charges in the month of June 2020. And the appeal memo was filed in 17 January 2020.
Ex gratia 50,000 and this you're appealing against. What is this? All that they've given is an ex gratia amount of 50,000. This is ex gratia, sir. It doesn't fix any
Yes, my
liability.
lord. The admitted fact of electrocution death, my lord. The only point of adjudication is
It's like a no fault liability, sir. 50,000. You are going to spend 1 lakh in this litigation itself. You might as well give that 50,000.
Let's say that is, I am the.
In fact,
mother
if you
of the
dismiss
deceased.
this cost of 50,000, you have to end up giving 1 lakh.
Your lordship, I am for the victim. And we have paid for 4 lakhs with interest.
No, that's
12%
right.
rate.
I think ex gratia because they've let it for civil remedy. No, but the Supreme Court has said it has to go to the Supreme Court. You've not filed a contempt for implementation.
No, my lord, I have preferred the rate appeal because my claim for against.
Anyways, that 50,000 your client should get.
Your lordship,
You're not interested even in that.
because I am challenging the impugned order, my lord.
So you'll give up what the court has given you. I have never
Obliged,
understood
my
this logic, sir.
Pardon, my lord.
This is remarkable. Your client has got some money. You're not interested in getting the money for your client. I don't know what. We've all been in the bar. I will be shocked if you'll collect that money subject to your filing a further appeal. Not that I'll give up the money that I was got. What is the logic, sir? And you never got this listed also.
Because
I think my lawyering days, we were different kinds of lawyers, I think. Your client has got some relief and you're not interested in getting, actually the client getting the relief. 3,000 is not a small amount for the. In plead, you see, and the oral prayer of the counsel for the petitioner, appellant. Opposite party number 1 is substituted by the Tata
Power Central Odisha Distribution Limited.
Tata Power Central Odisha Distribution Limited. Give the full address, sir.
Yes, I'll.
You say notice will now issue to the said substituted opposite party. Returnable. 3rd July.
Item number 17. Supplementary item 17.
None of this is missed.
Item number 18.
My lord, item number 18, I pray for a passover. Oblige your lordship.
Item number 19.
19 the state's division, my lord. The question on page 23. Whether on the facts and in the circumstances of the case, the London Sales Tax Tribunal fail in error by directing that assessment is reduced to return figure, even though it has not rendered any finding contrary to the finding of the authorities below, who held that Rasagolla being not treated as sweetmeat, it attracted levy of tax at the rate 14.5%. Question number 2. Whether on the facts and in the circumstances of the case, the order of the Learned Tribunal is legally justified to hold that the assessing authority had no material to make estimation of daily sales, particularly when the assessment order shows that the assessing authority has considered the cash position on the date of visit by the investigating officer.
What are the competing entries, sir?
Sweet meat, my lord.
And the other, what is the other? 10th February.
Item number 20.
May I please, my lords? The questions of law is at page 9 of your lordship's brief, my lords. Because I have already removed the defects and I've given extra copies to my learned friend, my lords. The questions of law is at page 9. I'd only request your lordships to come to question number B, my lords.
Yes.
And this is whether aluminium extrusion falls under entry 11 of part 1 of the schedule of the OET Act and is liable to entry tax at the 1% rate of 1% rules. This stands directly covered by a lordship judgment in case of the same petitioner, my lord, in for another year, my lords. And sorry, I'm giving you a copy. Right. I'll only insist on question number B, my lords. There, the lordship would kindly turn to page 2, my lords. This was the question which was being answered by your lordships, my lord. The same question, my lords. And ultimately, your lordships have.
It's not exigible to
months.
Right. You say admit the following question is framed. Question B. The above question stands answered in respect to the same petitioner for another year, assessment year 2004-5 by the judgment of this court in Messrs. Glamour Katak versus State of Odisha, 2022, 1 OLR, 2 ILR, sorry, Katak 579. In that view of the matter, the question framed is answered in the negative, that is in favor of the assessee dealer and against the department. Paragraph, the impugn order of the tribunal and the corresponding orders of the first appellate authority and assessing officer are hereby set aside.
This is for the assessment year 1/4/2012 to 31/3/2014. The present case.
All right.
That your lordship would get it at page 18.
All right.
Much obliged.
Okay.
So may I make a humble request to your lordship? most of the cases, my lord, the judgments are not being reported by the local journals, my lord, except the ILR. So, if
What to do? In fact, even Keshav Automobiles is not reported.
the saddest part of it, my lord, all these journals are registered in with your lordship's court, my lord.
And the law reporter should be directed accordingly because there is a law reporter here. He has to take care of all these things.
Conveniently, my lord, the important judgments, my lord. I don't mean only for this bench,
I know.
other benches, which are slightly bulky, my lord, are being ignored, my lord. And it's only coming at the year end in the supplementary or spread over to the next year.
Correct.
I'm sorry to make
No. We'll also do it. I think you people have to do it with the editors of those journals.
No, we are doing it, my lord, but Malas.
Which we are not always.
Correct. The only silver lining is that most of these are available online.
That's right.
I'm sorry to disturb you.
No, please.
Much obliged.
Right.
Item 21.
My Lord, Justice Raman, Honorable Justice Raman is concerned.
All right. Let's be for a bench office. 17th February.
Item number 22.
My Lord, in item 22, my Lord, the question of law has not been properly formed. I may be allowed time to find out.
All right. At the request of the petitioner who wants to reformulate the questions of law. List on. February.
Obliged.
27 is also same, I think.
27 is the state of it.
Is common order.
It is a common order.
That is also to be tagged to.
Yes, my Lord. That has been covered.
So item 27, list along with this item.
27, my Lord. My Lord, I pray for modification of the lawsuit directed to direct collector to pass representation before collector.
No. I think you're in some other matters, sir. Just hold on. Hold on, sir. I think you're in the weekly list or some other list. Just hold on.
29. He's in item 29.
29. We're not there. Just call out one by one.
Item 23.
None appears dismissed.
Item number 24.
24, my Lord, states revision, my Lord. So question of law is that page 35. Question number 1, whether on the facts and in the circumstances of the case, imposition of penalty is committed when the dealer is assessed to tax in the assessment order, section 42.
All right. Notice returnable 28th. No. Notice returnable 26 July. No, 24 July.
Item 25.
Item 25, 10 days time, maybe to remove the defects.
Or defects we removed. It's a list on 28 February. Defects we removed in the meanwhile.
Obliged. Item number 26.
26 also states revision, my Lord. The question of law is at page 34. Whether on the facts and in the circumstances of the case, imposition of penalty is concomitant when the dealer is assessed to tax in the assessment under section 9C.
9C. All right. Notice returnable again same day, 24 July.
Item 27.
They're dispensing with you, Alava, in item 24. What do you call it?
27.
27, my Lord, I pray for modification, your Lordship.
No. 27 is a sales tax revision, sir. Yes.
27, my Lord.
List along with item 23. 22 on the same date. Correct. I think dispensing with you can allow.
Item 28.
My Lord, item 28. My Lord, Justice Raman was there.
All right. Let's go for a. I don't know how much delay that is. Okay. Yeah. Let's go for a bench of which Justice Raman is not a member on 24th February. Right.
Supplementary list for orders, item 29.
Now you tell us, sir.
Item number 29.
29, I pray for modification, your Lordship. On that day, Lordship directed to file a representation, Lord. I pray, my lord, your lordship directed to specific time. I am in modification petition. I am given the deliver of representation my receipt, my lord. I pray, your lordship direct to collector. In spite of a representation, has not taken any action.
No,
Your
when
lordship
did you make,
direct-
when did you make the fresh representation?
But I pray for.
When did you make the fresh representation, sir?
When earlier I had given before. your
Not
lordship-
earlier. Now, after our order, when did you make the fresh representation?
When your lordship can appreciate, on that day, your lordship did not found my receipt, whether the representation delivered or not. That's why your lordship directed to file representation press. I pray for your lordship direct collector, I press representation, but same will consider the stipulated period. Man. I pray
No.
only, man.
No grounds to modify the order. Dismissed. Yes.
Item number 30.
Item 30, may I please? Now let's. Annexure 1, page 12 is the order under challenge before my lords. This is essentially an order passed under section 254(2) of the Income Tax Act. My lords, the assessee, petitioner assessee was subject to assessment, and the original assessment order was passed on 30th December 2011. Annexure 2, page 15.
All right, notice, accepts notice.
Lordship, it is appealable order. Your Lordship, see this order passed, Lord. He has to file appeal under 260A. He cannot file, Lord, the writ.
No, my lords. That issue, probably my learned friend is not aware that issue has been settled. My lords may kindly have a glance of the judgment.
Kerala.
This is para 7, my lords.
All right. You see, counsel for the department raises a preliminary objection that the impugn order is an appealable one. Counsel for the petitioner, on the other hand, relies on the decision of the Kerala High Court in Moidu's Medicare Private Limited versus Deputy Commissioner of Income Tax 2021 319 CTR bracket Kerala 187. See, reply we filed within 8 weeks. Rejoined for the next 29th August.
Item number 31.
May it please your lordship. Well, this is a PIL for cutting down trees in a forest land, for which Annexure 3 I have filed a representation before the DFO. No action has been taken, my lords.
All right, the petitioner's representation.
So let it go to Millets. These matters, Millets, can go before the
NGT.
No, my lords, it won't.
After your representation, let him go. The petitioner's representation, bracket Annexure 3, will be considered by the DFO, is it? Badrak, and after notice to the petitioner as well as opposite parties, 9 to 11, and after giving them a hearing, a reasoned order shall be passed not later than 10th April 2023, and be communicated to the parties within a week thereof. A copy of this order be sent by the registry to the DFO Badrak for compliance forthwith.
I mobilize.
Item number 32.
Please, your lordship. Is condition fixed for the physically represent the application and the tender papers, and the senior citizens and the physically handicapped who cannot participate in the tender process by this process, they can go for this online. I will make a representation, let them consider.
All right, counsel for petitioner states that he will withdraw, that he wishes to withdraw the present petition with liberty to make a representation to the authorities. If such representation is made not later than 13th February 2023, it will be examined in accordance with law by the. Whom will you make it to, sir?
Hopefully 4 miles.
To the by the Director General of Prisons. And after hearing the petitioner, a reasoned order shall be passed not later than 13th sorry, 20th March 2023 and be communicated to the petitioner within a week thereafter. The court clarifies it has not expressed any view in the matter.
Item number 33.
May I please, Your Lordship? Well, this is PIL actually. Here I'm challenging the amount of pension in the Madhubhav Pension Yojana, which is meant for old age persons. Now the amount is so insufficient, inadequate that a large number of persons are begging in the streets of Odisha.
You made a representation.
I made a representation, my lord.
All right. Petitioner's representation, bracket action 2, will be examined by the Secretary, Social Security and Empowerment of Persons with Disability Department, Government of Orissa. And after notice to the petitioner and giving him a hearing, a reasoned order should be passed not later than 17th April 2023 and be communicated to the petitioner within a week thereafter. The court clarifies it.
Madam, may I say something? One IA has been filed. The person's condition is not very good actually. So OP number 4 may be directed to take care of all these things. Actually, he has nothing he has to maintain his daily basic needs.
Who is this?
OP number 4 is the collector Puri.
The liberty may be given to approach the authorities. They'll take.
No.
Just a moment.
Just put down this IA 690 also along with that. You say it will be open to the. Then let the representation be examined by the collector then.
And that will be examined.
No,
but
because
so currently the condition is not good of that person. So
All right.
Direction will do.
You say a further direction is issued to the collector Cuttack. Collector Puri, is it?
Yes,
Puri. To examine the grievance made in IA number 690 of 2023 and ensure that basic minimum sustenance is provided to the applicant oblique petitioner. In accordance with law, under the extant policies oblique schemes of the state government. A copy of this order also be sent additionally to the collector Puri.
Item 34.
Wait, please, Your Lordship. Asserting the inaction of the opposite part number 4, my lord, to regarding on the representation of the petitioners regarding eviction of opposite part number 5 from the government land, my lord. The representation is pending before the OP number 4, my lord, Tahsildar. And the OP 5 has been found to be an illegal encroachment in the OP proceeding, but no, he has not been evicted yet.
Petitioner's representation, bracket annexure 5, shall be examined by the Tahsildar Bhuban and after notice to the petitioner and opposite party, number 5. And after giving them a hearing, a reasoned order should be passed not later than 10th April and be communicated not later than 17th. The court clarifies it is not expressed.
Item 35.
Please, Your Lordship. It's a PIL, my lord. Some Gochor land of the village was settled in favor of some private persons, my lord.
All right. The representation this time is annexure 7 shall be examined by the collector.
My lord, Collector Baleshwar.
Baleshwar, and after notice to the petitioner and giving them a hearing. The reasoned order shall be passed not later than 10th April. And we communicate to parties who will be there. The court clarifies it is not expressed.
Item 36.
My lord, in the appellate number 2 died, my lord, similar matter, my lord, fixed on 17.5.
All right.
17.5, my lord, similar matter has been fixed and allowed to substitute to.
All right. Counsel, the petitioner is permitted to substitute the deceased appellate number 2.
Appellate number 2.
With the LRs list along with?
Along with the 269 of 2020. WA number?
WA 269 of 2020 on?
About 2000. On 17.5.
17.5.23. All right.
There are 3 other cases.
Other cases 68, 69 and 70.
68, 69, 70.
It is arising out of 6 revision cases.
All right.
Item 37.
My lord, the matter is infructuous.
All right. Dismissed as infructuous. All right.
Item 38.
1 week timeline. Remove defects.
No, The order is in appeal. CIT A.
Challenge the appellate order.
Why can't you go to the ITAT?
In fact, ex parte order has been passed this.
So what? You can go to the ITAT. Counsel the petitioner seeks leave to withdraw the present petition with liberty to approach the ITAT in accordance with law.
Delay.
Such
maybe-
appeal is filed not later than 1st March, accompanied by an application for condition of delay. Citing the pendency of the present petition as a reason for the delay, the ITAT will consider it in accordance with law. The court clarifies it has not expressed any view in the matter.
I am for the department.
Item number 39.
My lord, this is the entry tax interest matter, my lord. That may be
2nd
taken up on
February.
2nd February.
All right, list on second.
Item number 40.
That 2nd February, they have to take out a separate list for entry tax matters. For more than 200 matters. Yeah.
Item number 40.
None of is dismissed.
I am appealing from the department.
All right.
Item 41.
Item 41 infructuous.
Infructuous dismissed.
Item number 42.
42 my lord is a GF tribunal matter minutes.
Mm.
The entire tax amount has been paid.
I see. The court is constrained to entertain the petition since the appellate tribunal has not been set up.
My
Notice-
appearance may kindly be noted.
All right.
Will also Mr. Tushar Gandhi Sarpati's name may be
Yeah,
deleted.
the name of Mr. T.K. Sarpati be omitted and the name of Shri R.P. Kar be indicated in the cause list for the petitioner. The notice, he accepts notice, reply within 8 weeks to join up the next day. Mr. Kar informs the court. You can put that IA 4211 of 22. You say Mr. Kar informs the court, the entire tax demand has been paid. In that view of the matter. During the pendency, of the present petition, no coercive steps will be taken against the petitioner. The IA is disposed of. Same for 43 also.
43 also.
Right, same one.
Your lordship are fixing a date.
It's on 23rd August. All right.
My lord, date of
Yes, your
order and
lordships
the
are-
filing of the writ petition. Date of the.
Lordships
Right.
are depriving us of many things.
Not at all. All right.
Item number
23rd of August. 23rd August.
23rd August.
Item number 44.
May I please, my lords. Lordship may kindly turn to page 72, my lords, which is the show cause come demand draft assessment order, my lord, issued under 148 4, my lords. The lordship would kindly turn to page 72 of the brief, my lords. Lordship got it?
Yes.
Your lordship may mark the date, my lord. It's 29th of March 2022, my lords. Then the lordship may kindly turn to page 75, my lord. Paragraph 3. Kindly submit your response
by 30th.
30th. And he passes an assessment order on the 31st minutes. So I was only praying.
Say
And if
notice.
your lordship and
No, we'll send it back.
So I'll just, my lord, if your lordship would kindly their own instructions, so the CBDT instructions,
I
you
know.
know, at page
So
87.
this is the end of the year. Same. End of the year syndrome.
And 87, my lord, they say that reasonable opportunity to comply with natural justice has to be given, my lords. I'm just
Target.
drawing
This
the
is all targets being fixed.
Yes, yes.
You say notice, he accepts notice. The challenge of the present petition is to both the notice dated 29th March 2022 under section 148 of the Income Tax Act 1961 bracket Act and the consequential assessment order dated 31st March 2022
and the penalty order.
And penalty order bracket annexures 2 and 2 by A and annexure 4. Bare perusal of the impugned notice dated 29 March 2022 reveals that the petitioner was asked to respond to the said notice within 1 day, that is by 30th March 2022. And the impugned assessment order was passed the very next day, that is 31st March 2022. Stop. Apart from the time being unreasonably short, this is even contrary to the circular dated 19th November 2020 issued by the CBDT.
At page 87, Lord, paragraph T.
Where in particular it has been emphasized. Turn to page 87.
87, paragraph T. Minutes.
Paragraph T, as under. Paragraph. For the aforementioned reasons, the impugned show cause notice dated 29th March 2022, the consequential assessment order dated 31st March 2022, and the demand as a result issued as a result thereof are hereby quashed. Paragraph. It is clarified that this will not prevent the department from proceeding hereafter afresh in accordance with law.
Your Lordship, he is to appear. Lordship, may observe that he is to appear. And
why should I appear, my Lord? Let
you first issue notice, sir.
His Lordship, that your Lordship direct to issue notice. Please.
Oh, no, we don't have to direct you to issue notice. We are permitting you to take steps in accordance with law.
Assessment order and the
no mandamus to harass.
I remember the previous was already stated.
In the other matter yesterday, your lordships were observing that we have not directed you to harass the petitioner.
Correct.
In Mr. Rai's case.
Yeah.
The penalty order is also to be quashed.
Yes, we can quash. Yeah.
Obliged.
All right.
Item number 45.
May I please, your lordship? My lord, in this matter, there are defects. I may be permitted to remove the defects within 1 week.
This is not an appealable order, is it? Order at 279(2)?
No, man.
Are you sure? Just the appeal. 46, is it? Against the commission. No, that's for the High Court. No, this is the principal commission, whether it's appealable to the ITA. 54, is it? No, 279(2). All right. All right. Say no. The what's the 15th February, defects we removed in the meantime.
Obliged, man.
Item number 47.
47, my lord, infructuous, man.
Memo taken under contest.
Item number 48.
None appeals.
Item number 49.
49, my lord, the lottery, e-lottery matter. Your lordship has already decision.
Same one.
49 to 53, my lord.
Oh, 49 to 53, all of this. All right.
Item 54.
My lord. On behalf of Mr. H.N. Mahapatram, I'll kindly let it 1 week after remove for defect, my lord.
All right. List on 15th February.
Obliged, my lord.
Item 55.
May I please, Madam? Madam, prior to this writ petition, Madam, the present petitions have taken the shelter of the Honorable Court under WPC number 2217 of 2021, and there is a direction from this Honorable Court on 10th August 2021, where it has been directed that the present petitioner they shall be heard in persons, Madam, but without giving opportunity to the petitioners, the opposite party number 2, the collector Balangir, basing on the report of the opposite party number 6, the excise inspector Kantamanji, he has passed the order, my lord. That is page number, my lord. That is annexure 3, my lord. From page number 12 to 14, my lord. May I read out the last para, my lord. After hearing the superintendent of excise Balangir and going through the documents, I am led to the conclusion that Behar Silet out still man shop is continuing as per the prevailing.
Not made that a party.
Madam.
Not made that shop owner a party. This Behran Select out still main shop. Somebody is running that. No, he's got a license for that.
Yes. Yes, madam.
You have to make him a party, sir. Without making him a party, how can you ask for relief?
But so I have to amend the
Counsel the petitioner seeks leave to amend the petition to impede the affected party. Add his request list on 23rd February. All right.
Item 56.
May I please, Lord? Now, here the petitioner shop was closed due to public objection, and my lord, here I have filed an application for exemption of MGQ, my lord, for the closure period, citing the decision of this on court. Till date, my lord, the government has not considered. That is under annexure is 18 is pending, my lord.
Annexure
have passed similar order directing the secretary to decide the representation. Annexure 18, my lord.
18.
Yes, and I have written annexure 18.
All right. Same order. All right.
Item 57.
57, my lord, here I have challenged the cancellation of license by the government without giving an opportunity of hearing and without assigning a reason under annexure 1, my lord. Lordship, can you glance annexure 1, page 12. Here, my lord, the show cause notice has been issued by the collector and the my lord commissioner, and the government has passed the final order. Your lordships have passed similar order. In the case I have annexed, I have filed a miscase, my lord. In the miscase, I have annexed annexure 1. Your lordship's order is there. The lordships have held that without following the principle of natural justice, the order is not sustainable and lordships have passed. Yes, my lord, Subhashi Sahu, that is order. Miscase, my lord, 669 of 2023, flag B, my lord. In that miscase, I have annexed annexure 1 because now they are going for settlement of the shop, my lord, through lottery on 2nd February. That's why I filed this miscase, my lord, and I have enclosed the lordships order. Same, my lord, pura same matter. Perimeter.
That is there.
All right. You say
it was passed when I was not.
I have corrected one order of lordship.
He's got all the templates.
I was not there.
No, my thing, my learned senior has proposed for challenging that in the appeal in the Supreme Court. I got information, but I don't know.
I was not present when this order was passed by this honorable court. So Samantrai was.
Only you have to change the name of council for the state.
Yes, my lord. State, yes. That I have not changed. Sorry, my lord.
All right.
Obliged.
Put down the mistake case also. Then say notice, accepts notice, then reproduce this order.
It is 58.
Item
58.
This is the second round of litigation. Your lordship, as the show cause notice was issued by the commissioner, that was set aside by this honorable court. Your lordship kindly see page 39. Page 39 of the brief. And giving the liberty to propose for fresh authority to proceed afresh in accordance with law. Thereafter, what happened? The collector has issued the show cause notice. I filed my reply to the collector, taking the plea that the collector has no power as per section 20 of the act. The state government has to issue. Just now, your lordship refer the Subhashi Sahu case. State government has to issue. Thereafter, lordship see annexure 12. This honorable court passed the impugned order, page 60. Lordship kindly see.
So you challenge the notice now.
Hello?
You challenge the collector's notice.
No, I am not yet challenging the collector's notice. Because the collector notice, your lordship by page 60, your lordship passed the order, kindly see, my lord.
No, prayer clause, come to the prayer clause.
Matlab, prayer is for the collector's notice for again annexure 13 for yes, my lord, collector notice for auction of the shop, my lord. What happened in this case, my lord? Your lordship directed to appear before the commissioner on 4th January. Page 60, your lordship kindly see. If not already passed, the excise commissioner will, on the basis of the impugned order dated 16 September 2022, where I have challenged in the previous writ application, the collector has no power to issue show cause notice, and he has rejected my reply and forwarded the government to take a decision. That's why your lordship directed you appear before the commissioner and urge all the points, even if the point regarding the jurisdiction of the collector to issue show cause notice or not.
Right.
I appeared before on 4th, my lord. And appeared before this order was passed by this honorable court on 15/12/2022, my lord. I appeared on 4/1/2023. Before that, on 3/1/2023, the collector had issued a notice for lottery of that shop, my lord.
No, commissioner has not passed the final order.
Commissioner, your lordship has directed for to pass within 1 month. Though my lord, I have filed an application.
All right. Notice, Mr. Mohanty accepts notice. It is pointed out by counsel petitioner that pursuant to the order passed by this court on 15 December 2022 in writ petition civil 33648 of 2022, he appeared before the excise commissioner on 4th January 2023.
Another similar.
And the orders of the excise commissioner thereafter are still awaited. Full stop. In the
4 weeks time,
so it's still awaited. Meanwhile, on 3rd January 2023, the collector appears to have issued the impugned notice offering the shop for auction. Correct?
May I suggest one thing to your lordship?
Offering the shop in question for auction.
In respect of serial number 1, my lord.
Correct.
It is there. May I suggest one thing to your lordship? The lordship may say that till the excise commissioner pass such order, this notice will be kept in abeyance and will be subject to the result of the.
It shouldn't be that immediately after the commissioner dismisses, immediately that.
But I may be interrupted. No, yesterday the matter was hard.
Yes,
but I have intervened there because there is another lottery notices there where I am the lottery winner.
No. What happened? I'm just clarifying. No, I'm just clarifying.
Lottery must have been conducted.
Previous writ application.
This already had.
This honorable court has already quashed the cancellation order and giving liberty to us. If the cancellation order was the cancellation order was set aside by this honorable court, then my license was restored to the restored. Thereafter, they have, if that is there, then what is the necessity to issue? If my learned friend is saying that is not held, this as per this notification, the lottery has to be.
This time he will join you. As
I have already challenged that notice before the commissioner. That was hard.
When is your petition coming up?
No, I have filed there. Challenging the collector's notice, I have filed there.
Status
because your lordship will apply.
You say no further steps will be taken vis-a-vis the shop in question at Balishira OS main shop
and one Kendupadar branch shop
with one Kendupadar branch shop till the next date of hearing.
Urgent copy, my lord, because the date of
my lord may fix it a short date because we have substantially proceeded for because our lottery has already been conducted.
No. 25 is the date.
You have trouble in your hands.
That has been set aside. That has been set aside by this honorable court. If the earlier notice is there, what is the second notification?
I will within 10 days.
What is the second notification again?
Challenging earlier notice, he had filed writ petition that was dismissed. Your lordship says the party.
What happened, my lord? If the earlier
Justice Jaswant Singh and your lordship there.
My lord, if the earlier notification is there, then what is the necessity of again notified for the same shop?
That's why I am claiming there.
Kindly don't quarrel with each other. Let me file the counter affidavit till everything
7th February. 7th
February. Obliged.
Right.
Obliged.
That's clear.
Item number 59.
None of you is dismissed.
No, my lord. My lord, unfortunately, I am in medical, so on a medical account. With my 1 week time, may kindly give it. I cannot open the.
All right. Counsel for the appellant is stated to be unwell. List on
Item 59, your lordship already decided the issue.
Meaning?
No. That is not.
And in connection analogous to the present writ appeal, writ appeal number 482 on 13th of December, your lordship also dismissed the writ petition, holding that the relaxation of age is the policy matter of the government. So your lordship
That's right. So all this has to be taken further. That's right. In view of the order passed by this court on 18/10/2022 in writ appeal 488 of 2017, these appeals are dismissed. All right.
Item number 60.
May I please your lordship? In this matter, the writ appeal has been filed little late, to which I have filed an application for condonation. The reason explaining that she was not well, madam.
What's the main matter about?
And in the meantime, the appellant has expired and I have already filed an application for substitution in place of the appellant, madam. I have also filed a miscase that is also on board, madam.
What's the main matter about, sir?
The main matter is that suit for partition has been filed and on contrast it has been allowed and decreed, madam. During thereafter, a commissioner was appointed and a commissioner report was called for to finalize the decree. That report has been rejected by the learned trial court. Thereafter, a second report was called for. That was also rejected. And thereafter, a third report was called for, wherein the learned trial court has passed an order to, as per the commissioner's report, the partition.
Writ appeal is not maintainable, sir. This is arising from a civil suit.
Yes, ma'am.
Writ appeal is not maintainable. An order in CMP, how is writ appeal made? You see, the challenge in the present petition, present appeal is to an order dated 14 August 2019 in CMP 478 of 2018. No appeal, writ appeal as such is maintainable against such an order which arises from a decree of a civil court. Leaving it open to the appellant to seek other appropriate remedies in accordance with law, the appeal is disposed of. First, allow the substitution. That will help you. And delay, you say, IA is allowed. Substitution is allowed, and then this. All right.
61.
In this matter, let's kindly allow my oral pair. The next code to be substituted by TPNODL. Tata Power, Northern Odisha.
The oral prayer of the learned senior counsel of the appellant. The appellant is substituted by TPNODL. Tata Power, Northern Odisha Distribution Company Limited. Then what's the main matter? Delay is what? How much delay? 121 days delay. Why?
Well, a delay is about 40 days.
No, 121 days.
No, 24/11/19 the order was passed. It was filed on 6/2/2020.
121 days. That's SR reports that. What's the reason?
My lord, review is a very substantial question of law is involved.
No. What is the reason for delay?
Reason for delay, my lord, we got the copy of the order. Thereafter, my lord, the Xmas vacation commenced. And we got ready.
You have vacation court, sir. No question of vacation. You see, the reason given for the delay of 121 days in filing the appeal is only that court vacations intervened. Full stop. It is well known that there are court offices keep functioning even during vacations. And in fact, matters are filed during vacations and even heard. Some very urgent matters are heard during vacations. Consequently, this reason adduced is not convincing. The delay is accordingly not condoned. Accordingly, the writ appeal is dismissed. All right.
But that is a substantial question of law is there.
The 2010 question of law is left open for decision in some other properties. All right.
Item 62.
Please, my lord. Item 62, my lord, is an appeal of preferred by the state. The delay is about 22 days.
Delay is condoned. What's the matter about?
My lord, this is the petitioner had assailed a relieving order. The petitioner was a Gram Rozgar Sevak. He had assailed his relieving order. My lords, the impugned order is at page 56, my lords. If I may place, my lords. It is second paragraph. It is hereby.
What happened to that 17928?
That writ appeal is pending, my lords.
When is it coming up?
Notice has not been issued on it. My lords, the distinguishing factor here is that the Gram Sevaks are contractual posts which there's an agreement. That agreement is for a year. Now that agreement was not renewed for this particular person. My lords, may I show the writ petition, the judgment that has been relied on in the impugned order? My lords, that, my lords, starts at page 58. My lords, may I take, my lords, to page 78 of that judgment? Page 78 of the paper.
No, he's continuing or not?
Yes, my lords, because after this, the judgment says that the entire action of the opposite party number 4 by issuing order dated 5/9/2019 relieving the petitioner from the post of GRS cannot sustain in the eye of law, and accordingly the same is liable to be quashed and is hereby quashed. So he is continuing in service as of today, my lords. My lords, the distinguishing factor is in Manas Kumar Swain's case, his agreement had been renewed post 2019. But in this case, my lords, our categorical submission is that the agreement was not renewed in a counter affidavit that has not been controverted in the rejoinder. The rejoinder has not been filed. So therefore, my lords, the respondent here does not have a case. My lords, I'll show, my lords, page 78, my lords, if my lords can take.
All right, just a notice returnable.
There's a stay application.
Not at this stage, sir. Already continuing means where's the question of stay? That's why I asked you. Notice returnable. Twelfth April.
Great. Item number 63.
My lord, I am on behalf of Mr. S.K. Patnaik, 1 week time for removal of defect and it's a file for limites.
Delays. 181 days delay, sir. We've not even filed an application for delay.
So 1 week times.
See list on in February, defects we removed in the file.
Item 64.
64, there has been delay. 1 year, 2 months.
The explanation,
And
the delay
the
is not
explanation is official.
All right. Following the judgments of Supreme Court in Living Media and Berulal, the delay is not condoned. IA is dismissed. Consequently, the writ appeal is dismissed. All right.
Item 65.
My lord, 189 days.
Same order here. All right.
Item 66.
Item 66, 67 and 71. That Sarath Parida matter.
How many matters, sir? Huge batch.
My lord, I will furnish the list by tomorrow.
That's
so
better.
that all the matters will be taken up on the 8th May and
Correct.
Lordship may direct for issuance of notice.
Correct. Just mention it.
I will furnish it tomorrow, my lord.
All right.
The entire list.
Same order.
Item 68.
None appears dismissed.
Item number 69.
Same. 70, same.
Item 70.
Same.
71 is these matters. Item number 72.
None appears dismissed.
Item number 73.
68, 69, 70.
All over.
That is already Arjun, the writ appeal along with 47 perhaps.
Oh, I see.
That is.
Correct. The same substitution of LR.
Substitution
of appellant number 2. The same person mentioned.
Yeah.
All on 17th May. 17th May, is it?
17th May.
Correct. You're right, sir. Thank you.
36.
72. 72.
72.
No, 73.
72.
None appears dismissed. 73.
Item 73.
This is the matter, my lord, wherein an order of remand from the Supreme Court.
Supreme Court. Correct.
Whether such a power is available under law to be exercised for banning the petitioner's organization. That is the only question, my lord. Can I go through the Supreme Court's order? Yes. said, we have heard on a counsel for the
No,
party.
no, what is Mr. Katkia?
Yes.
Ah, there is.
I'm there. I want little more time to have a research plus. I got very short time to get preparation. Yesterday in the night I have got back. Because even Tuesday.
No, can't be Tuesday. Mr. Katkia prays for some more time, getting ready with the matter. August 16th. All right.
Item number 74.
In item 74, Your Lordship, the state has filed a counter affidavit on 9th of January, Your Lordship. I will file a reply to it, Your Lordship.
All right. Rejoinder will be filed before the next date. 17th August.
Item number 75.
My lords, I am appearing on behalf of Odisha. I'm sorry, my lords, I'm on VC. I've just hurt my toe.
No problem. No problem.
My lords, I filed a short note on submissions. My office is to hand it over to your lordships.
Right.
Copy.
My lords, yes, copy to the state. My lords, in this case, I've gone through the affidavit filed by the opposite parties 1 and 2. Because there are certain, I would request your lordship to, in the affidavit, I find a huge difference between, as your lordship had noticed on the last occasion, huge difference between the receipts and the disbursement.
So 881 crores is unutilized.
It's 17 till 2017. And at present, it's 539 crores, 540.
Correct.
Number 2, my lords, is that they say that the cess which is collected from the employers, which I've mentioned in my page 4, paragraph 5, that cess is collected from the employers as per cess act.
Correct.
50 per beneficiary.
We'll have a special audit. I think that's the best way to do it.
Yes, my lord. And also, if opposite party number 3, which is the board itself,
right,
if they could file as to what is happening in the board.
2018 5 SEC, can you get it? 2018 5 SEC 606. Let's get the judgment.
My lords, 3 issues, my lords. Last time, my lords had flagged 3 issues. The first was, my lords, why was there a dramatic drop in the registration?
Yes.
So that, my lords, since May of 2022, my lords, you have started an end-to-end, which is a completely online process, my lords. So it took some time to get that system up and running so that there'll be some familiarity with the beneficiaries and as well as the officers, my lords. So, my lords, in fact, as of December 2022, the number has now increased from 75,000 to 1.26 lakhs.
Nothing. So, you look at the number of workers, but one city itself sometimes it will be more.
But the issue is
with this hockey and all going on.
Yes,
number of workers will be
definitely more. It's just that because of this online thing, it's taking some time. Like every new system, my lords may appreciate it takes time. With our e-filing system, also it's picking up, my lords. So
bad analogy.
There's I understood. One is that, the other is with regard to the collection from the workers, millers. On that count, millers may see para 5. So till about 2018, 2019, there was no separate account being maintained for these contributions under this head. From 2019 onwards, there's a separate account. And in that account, millers, we had received about 38.2 crores. Out of which 35 crores has been transferred to the welfare fund, my lords, and that is, my lords, being thereafter disbursed to the beneficiaries, my lords. That, my lords, will find at page 4 of my affidavit. So those were the first 2 things. The third issue that my lords had flagged was with regard to the
that balance itself is 579 crores, sir.
Please, my lords, that balance is there, but my lords, I must apprise this court that if my lords may see the numbers in the last 2 years, which is the COVID year, only because we had this cushion of this balance that could be used to infuse, because we had to give 1,500 rupees per worker apart from all the benefits that the person is entitled to. So for these, my lords,
it's for these workers' money. Actually, it's very sad. Each worker is paying 50%.
Please, my lords.
50 rupees per annum and then 20 rupees for registration.
Please, my lords. So, my lords, my lords may take my previous affidavit, page 48. Which is annexure N by 1. If my lords may take my previous affidavit, which I had filed on
5th December, I think you had filed.
23rd. My lords may have my previous affidavit, annexure N by 1. I just wanted to apprise this court of the numbers. My lords, 2020-2021, the amount disbursed was 518 crores. And my lords, the amount of cess which was collected for that year was 361 crores. Same, my lords, 21-22, 454 crores was collected and 544 crores was, my lords, disbursed. So the cushion that the board had, my lords, that surplus amount, that was used for during the COVID time. So there has to be, my lords, some surplus. My lords may appreciate some surplus has to be there with the board, my lords. Well, it's page 48, annexure.
We don't even know when you say you have disbursed, we don't even know how many beneficiaries actually got money or how you've disbursed. Nobody knows. That's the whole problem. Unless you have an audit, you will not know whether this disbursal also is correctly done. It is in your own interest. Let there be an audit.
Yes, my lords.
My lords, and if OP3 could appear to give a clarity on the situation, that's a board itself. OP3 is the CEO, Odisha Building and
Plus,
other
in fact, these accounts are audited by the accountant general.
No, we're talking of a special audit.
Please, my lord, if my lords so directs, my lords, we'll have a special audit.
Because undisbursed amount is huge.
Please, my lords.
Special cost special audit. Just come to your 23rd November 2022 affidavit. Annexure C by 1.
Please, my lords.
Correct. 12.
Audit of fund shall be conducted by the local fund audit organization, the accountant general audit.
May also cost special audit.
Special audit. Yes.
So you have a special audit. I think that's
Please. And the third issue, I must complete. As the third issue was with regard to the discrepancy in the numbers that were given before the Honorable Supreme Court. So, to that, my lords, those were provisional numbers. As my lords may see in the order also, the annexure says that this is provisional. So, after that, it has been revised, and we have given the revised figures. That's page 4 of my present affidavit.
Revised happens to be more than the provisional.
Not flagged.
My lords, if I may add that OP number 3, the board, my lords, I have stated in my note that all these 3 kinds of contributions are put in different heads, my lord.
Yes.
My lords, I just had this one more submission to make, is that the welfare board, which is OP number 3, can also clarify as to each of these 3 contributions, my lords, the cess, the registration of 50 rupees, the annual contribution of 20 rupees, all are supposed to be put in different heads, as I have pointed out in my note, my lords.
Right.
So the board can tell us exactly how OP1 and 2. I mean, the affidavit says for OP1 and 2. OP3 is Chief Executive Officer, Odisha Building and Other Construction Workers Welfare Board. That has not filed any affidavit before us.
The welfare board is a separate
Yes,
party,
ma'am.
sir.
Maybe board can clarify as to exactly how much we had collected from the workers, from the people, and from the employers.
I'm told that they have a different council.
Who's that?
Notice has to be issued.
Maybe as your lordship felt from your lordship, that special audit might clarify all these issues.
And pursuant to the order passed to this court on 8th December 2022, an additional affidavit has been filed by the District Labour Officer Cuttack. Stop. As regards the significant drop in the number of beneficiaries and the corresponding amount disbursed under the Odisha Building and Other Construction Workers Regulation of Employment Conditions of Service bracket rules 2002 bracket rules bracket. It is sought to be explained that a new online portal of the OB and OCWW board bracket opposite party number 3 with end-to-end service delivery was launched on 1st May 2022. And there were some teething troubles. Full stop. It is now claimed that by the end of December 2022, 1.26 lakhs construction workers have been registered and an amount of rupees 154.62 crore of benefits have been disbursed to the eligible beneficiaries during the financial year 2022-23. Full stop. On the second issue of not accounting for the contribution made by every construction worker in terms of Rule 267 of the rules, it is stated that till 2019, the various contributions collected in the form of cess, application fees, and annual contribution of registered workers were maintained in a single account. Stop from 2019-20, a separate account has been maintained for each of these receipts. Paragraph. As regards the non-implementation of the directions issued by the Supreme Court in National Campaign Committee for Central Legislation on Construction Labor versus Union of India, 2018 5 CC 607. It is now contended that the figures provided to the Supreme Court were single quotes, provisional figures, unquote, which have since been revised, reconciled and revised. Stop. The provisional cumulative amounts spent on the beneficiaries as on 31/3/2017 is stated to have been revised from rupees 361 crores to rupees 389.50 crores. Stop. After reconciliation, the cumulative cess amount collected has been revised to rupees 1170 crores. Paragraph. Ms. Mrinalini Padi, the learned counsel for the petitioner, has placed a note before the court in which, after analyzing the figures provided by the state in its affidavits, she points out that by the end of December 2022, a balance of rupees 579 crores, 579, 49, 41, 575 remains unutilized. Full stop. This is not disputed by learned counsel for the state. Full stop. Paragraph. Considering that the unutilized amount is considerable and the act itself and the Building and Construction Workers (cess) Act (CW Act) was meant essentially to cater to the needs of the construction workers, building and construction workers. The court considers it necessary to require the state to get a special audit undertaken of all the amounts collected under the Act and the rules and the disbursal of the amounts so collected, keeping in view the directions of the Supreme Court as well as the object and spirit of the Act and rules. Paragraph. It must be noted here that the requirement for a special audit has been noted in para 12 of a resolution dated 15th December 2008 of the Labor and Employment Department, Government of Orissa, which reads as under page 80, paragraph. With there being a gap in the with there being a revision and reconciliation of the earlier figures of registered construction workers and the present figures as disclosed by the state government. And with the undisbursed amount being in excess of rupees 579 crores. The court directs us under one, the state government will have a special audit of all the amounts collected under the Act and collected and disbursed under the Act conducted within a period of 4 months from today.
Let's make it 6 months because
or within a period of 6 months from today. Full stop. 2, the opposite party number 3 board will ensure that there is a separate accounting of the amounts collected under three broad heads, namely from the employer in terms of Section 3 of the Act, 2 rupees 50 per beneficiary collected under Rule 267 of the rules from each construction worker, and 3 is 20 collected from the construction worker for registration under Section 12 bracket 3 of the Act, are separately and properly accounted for. 3, the board will file an affidavit that the provisions of the Act and rules are being strictly followed in letter and spirit, and that the benefits reach every construction and building worker as is intended by the Act and rules. Paragraph. The report of the special audit be placed on record with an affidavit by the state government before the next date. Based on July 31st.
Great.
Yes, please.
Item number 76.
May please your lordship. This is a PIL matter, my lord. Matter relates to revival and preservation of water bodies in Cuttack city. This matter, my lord, appears today's list as per order number 19, dated 13/12/2022, my lord. I would like to place the relevant paragraph of the said order.
Affidavit
which
is already filed on 17th January.
We have not been given any copy, my lord.
Serving now, right now. Serving. The hard copy also I have filed today.
Let a copy be served.
Yes, I will serve.
And I may be allowed some time to examine the same, and if necessary, I will file countermeasure.
They've set up a water body rejuvenation unit. Is a copy of the affidavit dated 17 January 2023 filed by the opposite parties 1 and 2 be served on counsel for the petitioner. Today itself. Full stop. He is permitted to respond to the said affidavit before the next date. Paragraph. In the affidavit, in the aforementioned affidavit, it is stated that the Housing and Urban Development Department has constituted a single quotes water body rejuvenation unit, unquote, which is expected to map all available water bodies. Full stop. It is stated that all collectors, commissioners of municipal corporations, executive officers of municipalities and notified area councils have been directed by a letter dated 6 December 2022 of the state government to submit single quotes relevant information for ecological restoration of water bodies, unquote. It is stated that the Housing and Urban Development Department has also single quotes onboarded Mission Shakti groups for participation in the water bodies rejuvenation initiatives. It is stated that the guidelines Which guidelines are these, sir? Just come to para 7 of your affidavit.
Yes.
What are these guidelines?
Guidelines of the government of India, I think. Para 3.
Scheme guideline. All right. No, that's your own guideline, I think.
Yes, ma'am.
Mukhyamantri Karma Tatpara Abhiyan. No, this is some wage employment scheme. That is the same thing as guideline. No, these guidelines that they're referring in para 7 is not this. So is this the same thing as guideline? Well, let me explain. You've come to para 7.
Yes, my lord, but a format has been prescribed and all are instructed to paras.
There is some scheme guidelines at page 14.
Page 14. Yes. Scheme guidelines for Mukhyamantri Karma.
But the scheme is for something else, no? Employment, urban wage employment scheme. So it will also include maintaining water bodies.
Yeah, that is.
It appears that the work of rejuvenation of water bodies is sought to be taken up under the Mukhyamantri Karma Tatpara
Abhiyan
bracket Mukta. The guidelines for which have also been enclosed with the affidavit.
Page 18, paragraph 7.6. Page 18, paragraph 7.6. Drainage and sewage work, except desalination, sanitation work, water conservation and rainwater harvesting, structure, development and renovation of water bodies. These are the correct. These are covered in Mukta.
Correct. A further affidavit we filed for the next date, giving an update of the progress made in the rejuvenation of water bodies under the aforementioned scheme. List on 24 July.
My lord, in the connected matter, my lord.
Copy of the affidavit may be.
I'm serving.
My lord, in the connected matter, first noting is inadvertently second copy of the response of affidavit of number 2. I have not filed. First copy I had only filed. I am filing it now. And the consolidated cause title, I am filing.
All right. To come up on next.
Item 77.
My lords, kindly turn to order dated 27/6/2022, my lords. My lords, here, my lords, registration certificate was cancelled for non-filing of the returns, my lords. The petitioner filed appeal. All the appeals were rejected, and considering, my lords, in earlier cases, has already passed order resorting to Rule 20, proviso to Rule 23. If that is, my lords, in spite of the order, my lords, till date it has not been done, my lords. The order dated 27/6 was not complied with till date, my lords.
My lord, in the meantime, your lordship passed the order. The registration we can't be.
That order was already filed, passed earlier, my lords.
In spite of the order, they are not
No,
complying.
it's already passed. Similar orders already passed.
My lord, 27/6/2022.
You enclosed it here.
My lord,
In this case, sir, similar order was passed in this case.
yes, my lord.
When?
27, order number 3, my lords. 27/6.
This separate order, after that registration, after that order has been passed for then registration of registration matter.
27/6 is not this kind of order, sir.
My lords, rule 23 was,
Only contention is noted. No
Well,
order is passed.
your lordship.
We start voting from para 3 onwards. Take this order from para 3 onwards.
My lord, in the meantime, order has been passed. Order has been passed, my lord.
When?
Registration, it is a matter of cancellation of registration. Your lordship passed the order in so many cases.
Correct. He wants a similar order, sir.
Yes, yes.
So no order is been passed. But I know idea was there. But actually, so 3, 4 onwards. Same order. Para 3 onwards. Same para. All right.
Item 78.
May I please your lordship, I on the behalf of Mr. Mahapatra, government has not filed a affidavit.
For last 2 occasions, your lordship is specifically directing him to serve copy on the state. My office is showing that copy not served. We are not, today you serve the copy in front of the court.
I have served 8 set of copy on 11th October 22.
8
On
set.
whom?
Let me see the receipt. But the office. School and mass education.
They have served all the copies
But the
to
direction
our
was
office.
to me. You go through the.
It was a direction dated 29th
Last
March
order.
2017.
This is school and mass education, you have served copy. I don't dispute that. But the direction was to, they have to serve copy. If they don't need to serve copy to us, we have nothing to say.
Sorry, my lord, I serve a copy any next year.
No, you are appearing for whom, Mr. Manti?
The opposite party number 1, government. I
No,
think.
5 to 8.
5 to
8.
I have no.
Another copy of the writ appeal be served on Mr. D.K. Manti, AGA, who appears for opposite parties 5 to 8 today itself. The order passed by this court on 29 September 2022 shall be complied with. Now by the state by filing its replies within 4 weeks. Rejoinder that to be filed before the next day. 21st August.
Lordship may say Ishwar Mohanty additional sending counsel. Not me.
All right. On Mr. Ishwar
Additional sending counsel.
All right.
Item 79.
No instruction on behalf of Susan Mishra.
All right. No instruction.
Item number 80.
Manner please dismissed.
Supplementary list passed on matter item number 18.
This is a review petition. With regard to the order dated 29/2019 passed by your lordships in WBC number 5671 of 2019, there were 4 engineers who were terminated. 2 of them raised an industrial dispute. One industrial dispute went to the industrial tribunal, the other before the labor court. As far as the other one, which was decided by the industrial tribunal categorically held that he is not a workman under Section 2S. Now, both of them are engineers, and this man, he got a favorable order from the learned labor court, and which was under challenge before your lordships. And now the salary which he was getting, admittedly, the salary was 18,317 per month. Can I take your lordships to the writ petition? The annexures 4 and 5 to the writ petition. Will your lordships take?
Yes.
Can your lordships go to the writ petition first? That is writ petition civil number 5671, out of which the impugned order arises. If your lordship will go to first to page 63.
Yes.
Your lordship has it?
Yes.
If your lordship will look at the appointment order of the respondent, the management is pleased to place you as supervisor operational in the supervisory staff cadre, ESS 1, at the company's power plant at Kharagpur, so. And if your lordship will look at the monthly salary, it is 15,426, and the yearly salary is 1,85,112. Now, if your lordship will turn over the page at serial number 5, during the period of probation, either party can terminate the services by giving either the other party 1 month's notice or salary in lieu thereof without assigning any reason. Subsequent to confirmation, the services are terminable by 3 months' notice or payment of 3 months' salary on either side. Salary for this purpose shall consist of only basic pay, dearness allowance, and special pay, but not other allowances or benefits. Now, your lordship will turn over to page 66. Annexure 5. Your lordship has it?
Yes.
Consequent to review of your performance during probation, the management is pleased to inform you that your services are confirmed in the position of supervisor operation in the supervisory staff cadre with effect from 14/12/2003. Further, you have been granted an increase of.
Yes.
Second paragraph. Further, you have been granted an increase of rupees 30,324 in your CTC per year. As such, your revised CTC will be 2,19,804. And all other terms and conditions of employment set out in your probation order remain unaltered. So therefore, in effect, the clause 5 at page 64 also was not altered. The initial engagement. And this comes to 18,317 per month rupees, the salary. Identical orders, and this order was placed by way of an additional affidavit before your lordship on 8th of September 2019, and this order has not been dealt with by the High Court at all. The industrial tribunal, in respect to another engineer who was appointed in the same category, that order has not been there, and it has attained finality. If your lordship will look, we filed an additional affidavit on 8th of September 2019, enclosing the photocopy of the certified copy of the award dated 30/3/2019. And that is the Industrial Tribunal Award, which is directly in conflict with the present award passed by the Learned Labour Court. And this aspect has not been dealt with. And
What
if
have
your
you done
lordship
as far as the main matter is concerned? The order under review, because it's a 2019 order.
Yes, my lord.
So
Yes,
there is
my lord.
no stay, nothing. So what has happened?
No, my lord. There is a delay of about 41 days in filing this review petition.
No, that apart.
Yes.
Once the Labour Court's award has been upheld.
Yes, my lord.
What's the result?
Because there is an error apparent on the face of the record. There is an industrial tribunal award which upholds the termination order, says that you are not a workman under 2 cess.
No, 1 minute.
And this is the
leave granted to the workman was reinstatement with
yes.
back wages subject to deduction of 45,000.
Yes.
Right. What has happened? Have you taken him back? Have you paid him his back wages?
No, my lord, we have not. We filed a review.
No, but there is no stay, sir. See, in the High Court here, there seems to be a presumption that once you file a petition, there is an automatic stay of any order that you are challenging. That seems to be the presumption by and large across the board.
I'm not saying that. I'm not saying that. I'm completely in agreement with your lordships. But the problem here is, your lordship will appreciate, 4 engineers were terminated. 1 award in respect of 1 engineer passed by the industrial tribunal, which has attained finality. The award goes in favor of the management. Another award passed by the Labour Court, holding that he is a workman under 2S. Conflicting orders.
But still, unless you get the order which is against you stayed, you have to implement that order. Award, in this case, award.
That's why we have come before your lordships in a review seeking a stay of that order now.
No, I understand. The petition is listed today for the first time. If this is your understanding, then we have nothing to say. You have simply lodged a review petition and you have given yourself a stay, thinking you are under no obligation to implement the order of the court. And this is a review petition. What is surprising is, this is a review petition. The main order has already gone against you. That order you have not even challenged in the Supreme Court. By merely filing a review, you've given yourself a stay of the implementation of the award itself. This is extraordinary.
At the outset, I told you, I made my submission that I'm in complete agreement with your lordships, whatever is falling from your lordships. But the problem here is that we filed a review. Therefore, we did not file an SLP before the Supreme Court. The review was pending here. Tomorrow, if you would have filed the SLP,
19.
Tomorrow, if you would have filed the SLP, the Supreme Court would have told us that you have filed a review, go and pursue a remedy there.
What is the amount work out to, sir? What is the amount due to the workman work out to?
Well, the entire salary, that would be about 3-4 lakhs, apart from reinstatement.
So you at least deposit that entire amount in the court. That's the least. That's the least for us to issuing notice in the review.
We will deposit that within a period of 4 weeks. Your lordship will grant me 4 weeks.
It is seen that despite despite this court having dismissed the writ petition filed by the management way back on 20th September 2019, thereby upholding the award dated 26 July 2018, passed by the Labour Court in favor of the respondent workman, opposite party workman. Till date, the petitioner has not implemented the said award, which required the workman to be reinstated along with back wages minus rupees 45,223. Full stop. it was made clear in the labor court's award that if the award is not complied within 1 month from that date, that is 26 July 2018, the workman would be entitled to interest at 6% per annum on the awarded back wages till it is realized. Paragraph. Mr. Mishra, learned counsel for the petitioner, states that since the management had filed the present review petition on 8 March 2019, can be 8 March, sorry, on 29th November 2019, it did not consider it necessary to implement the award. Stop.
I didn't say that.
Interestingly, it is only on 2nd January 2023 that an application being IA-1 of 2023 has been filed. Seeking stay of case 2CCC number 27 of 2019, filed by the workman before the SDJM Denkana for implementation of the award. Full stop. Paragraph. Given in the above background, court directs that the petitioner will first deposit in this court the back wages ordered to be paid to the workman by the labor court, together with the interest as ordered by the labor court on or before 1st March 2023. Full stop. The court will consider the issue, will consider whether the notice needs to be issued in the review petition, subject to compliance with the above direction. Stop. List on 9th March 2023. All right.
Can I just make a prayer if your lordship?
Yes, please. Yes, please.
Can your lordship stay the proceedings in the meantime?
No, sir. No.
We will deposit it. I can
No,
assure
if you deposit, if you deposit, we'll see. Yes.
Could your lordships then grant me 2 weeks' time, and if I do not deposit, then your lordships may say that the interim order will be vacated?
No.
Give me 2 weeks' time.
No.
That amount.
No.
Your lordship will just give me 2 weeks' time.
You undertake to deposit earlier, we'll record that.
No, but your lordship may protect me.
Whatever date, if you say you're going to deposit by 27 January, you say it, we'll record that.
Uh, 27 January will be too early, but if your lordship will just give me 2
whatever
weeks'
date.
time.
No.
2 weeks.
You give us a date when you will deposit.
We'll deposit by 1st of February.
All right.
Maybe 2nd of
You
February.
say counsel the petitioner undertakes to deposit the aforementioned amount on or before 1st February 2023. List on 7th February 2020.
Very grateful, my lord. Very grateful.
Right. Weekly list.
Weekly list. Item number 94.
My lords, I may be permitted on behalf of Subhashish. My lords, I'm submitting a written note.
No, this is a sell deed after the order. Sorry, prior to the order, he has purchased. So it will be remanded.
My lords, let it be remanded.
All right.
And I may be provided with an opportunity of hearing, my lords.
Yes, that is usual part. The land was resumed without hearing the purchaser.
Correct. Considering that the impugned order of the additional Tahsildar Bhubaneswar, considering that the impugned order dated 14th, is it January or February?
14/2/2021.
14th February 2002, the additional Tahsildar Bhubaneswar in WL case number 1099 of 1973 was passed without notice to the present petitioner who had purchased the land in question from the original lessee by way of a registered sale deed prior to that date. The said order is hereby set aside, and WL case number 1099 of 1973 is restored to the file of the additional Tahsildar Bhubaneswar, where it will be listed for direction on 2nd March 2023, on which date the petitioner will appear together with the downloaded copy of this order. So the additional Tahsildar is requested to proceed with the said case on merits thereafter and dispose it off within a period of 4 months. Full stop. Till such time, status quo as of today shall be maintained. The petitions are disposed of. Both petitions.
Yes, my lords. 94, 95.
Right.
My lords, I may be part of my lords.
94, 95. There are three writ petitions.
94 both cases.
And 95, there's one case.
My lords, I may be pardoned. Item
Yes.
83 somehow has been missed, my lords.
Sorry, item
83 of the weekly list.
83.
Yes, my lords.
If you're ready, we can take it up now.
My lords.
83. All right.
83, my lords. Here, the petitioner is a trust, my lords. My lords, it had
What about
lands from IDCO. My lords, a big patch of land about 17 acres, within which they did not notice that there was another patch which was not actually in the name of IDCO, my lords. Now, when they found out that this 1 acre area within the 17 acres is not within the my lords.
No. So in this, I think IDCO is represented by Mr. Gautam Mukherjee, right?
Yes, my lords.
Your Lordship, I am appearing. Your Lordship, I am appearing on behalf of my learned senior, Mr. Mukherjee, for opposite party number 4 and 5.
Okay, all right. Yes, Mr. Karun, please proceed. Yes.
My lord, here 17 acres within which there was a patch which of 1 acre which belonged to the Panchayati Raj department. So we apprised IDCO that if this patch remains within this premises, which will be utilized for a college as well as a school, my lords, this will work out a lot of inconvenience for us. So what IDCO did, it wrote to Panchayati Raj department to give us the land, to transfer the land to IDCO so that it could be transferred to us. Now Panchayati Raj department also agreed to this. My lords, that is at running page 24. They said, let them pay the market cost, which is about 26 lakhs, and take the property. We have no objection. We'll transfer it to IDCO, and IDCO can transfer it to the trust. Now, my lords, IDCO has filed a counter. It also says that it has asked the government to reconsider. In the meantime, government, as usual, my lords, realizing that this will cause inconvenience to us, has cancelled this proposal. I've deposited 26 lakhs pursuant to their, my lords, that is at running page 24, if your lordship sees. Panchayati Raj Annexure 3. Sorry, ma'am. This is Annexure 4. Yes, ma'am. My lords, this is from the Panchayati Raj department, page 23, Annexure 4. To the Managing Director, IDCO Towers, Janpad, Bhubaneswar, subject no objection for relinquishment of land, plot number such and such, reference IDCO letter number such and such. I am directed to inform you that Government and Panchayati Raj Department has no objection to relinquish the said land bearing number such and such, khata number such and such in district of Khurda for alienation in favor of IDCO with the following condition: the present market rate of the abandoned half-constructed building on the land to be assessed partly by the Panchayati Raj Department, IDCO and DRDA shall be deposited before the DRDA Khurda. You are therefore requested to do the needful. Accordingly, this was assessed at 26 lakhs by the next annexure, annexure 5, and that I have deposited. Now, suddenly, my lords, by annexure 1, they say you take back your money, we want to build up a resti in it, rural employment, my lords. This is bang in the middle of my allotted premises, my lords. They have enough lands otherwise, my lords, across.
What is IDCO stand?
IDCO stand is, my lords, they have requested the government to reconsider this proposal because it will lead to inconvenience to the land allottee, that is us. That is there in
Annexure 10, page 30.
All right, which means only the government which has to now make
Yes,
stand clear.
Yes, my lords. IDCO in principle is in our favor, my lords.
Right.
In paragraph 15, it has requested the Panchayati Raj Department.
See, if the land is in the midst of a larger patch,
yes, my lords,
it can't be used. It's a status quo continuing for 7 years, 10 years now.
Lordship may direct the Panchayat for to reconsider the proposal.
All right.
As
say the present writ petition has been filed challenging an order dated. The communication dated 23rd April 2012 issued by the Orissa Industrial Infrastructure Development Corporation bracketed Co. to the petitioner, stating that the earlier proposal of the government of Orissa to transfer the half-constructed building of the DRDA/ZP Khurda, along with land measuring AC 1.000, situated in plot number 2321 bracket P in Khata number 787 bracket new plot number 2321/4363 in Khata number 525/1276 bracket of Moza Makunda Prasad village has been cancelled by the government of Orissa, since it proposes to utilize it for setting up a rural self-employment training institute. Full stop. Further, the petitioner was informed that the sum of rupees 23,71,700 made by it on 10th August 2009 is being returned. Paragraph. It must be noted here that the above proposal of the government to allot the said land and transfer the half-constructed building to IDCO, for in turn being handed over to the petitioner, was pursuant to the request of the petitioner. Made to the government that the said patch of land, which is in the midst of a larger piece of land already allotted to the petitioner, should be handed over to it. Full stop. Paragraph. While notice was issued in the present petition way back on May 2012, an interim order staying the operation of the above letter was passed. So that stay order is continued till date, which means for more than 10 years. Paragraph. While IDCO has filed a reply to the petition largely supporting the stand of the petitioner, till date, no reply has been filed by the state government, which is represented through the Panchayat Raj Department. Paragraph. Considering that the aforementioned stay order has continued for more than 10 years now, A direction is issued to the Secretary Panchayati Raj Department to reconsider the entire issue of cancelling the earlier proposal. To hand over the above half-constructed building together with the plot of land of AC 1.000 to the petitioner. What have you done with this money, Mr. Kanugu?
Manoj is still lying with them. No, we have brought it back. Sir.
No.
It's returned.
That is what I was also searching for, whether, because they must have
encashed the check.
Encashed the check.
The amount of made by the returned back. White check.
Your Lordship may take Annexure 1 for.
No, I know, but whether these people have encashed the check is a question.
Fact remains, the state has not received this amount as on today. This amount is not with the state.
Then you'll have to pay that present market value.
Yes, that is what I am also searching, that present market value.
It may be noted at this stage that Mr. Milan Kanagol, on its senior counsel for the petitioner, states that since the amount should return to the petitioner along with the impugned letter way back in April 2012, the petitioner is prepared to pay the current market value
Yes.
of the said patch of land. Stop. The stand of the state government we made clear by an affidavit to be filed on or before 1st May 2023.
The Lordship is not disposing of this. The Lordship may direct that if the state government will consider this proposal afresh on the basis of the recommendation of the IDCO and pass necessary orders, because IDCO has recommended in their favor. And your Lordship has already fixed the guideline that current market value. So government will take a call.
On the above basis, the Panchayati Raj, Secretary Panchayati Raj Department will pass a fresh order on the petitioner's request on or before 1st May 2023 and communicate the decision to the petitioner on or before 8th May 2023.
And it may be June, 1st May and 8th June. 1st June and 8th June.
All right, 1st June and 8th June. Till then, the status quo as of today shall be maintained. Full stop. Needless to state that if the petitioner is agreed by the fresh decision, it can seek appropriate remedies in accordance with law.
Order may be communicated to the Secretary.
Petition is disposed of. A copy of this order be communicated to the Secretary Panchayati Raj Department.
Deeply obliged.
Right.
Obliged.
Item number 96.
None appears dismissed.
Item 97.
97, Your Lordship, I have no instruction for the timing. Your Lordship may say if cause of action survives.
It's a 2014 matter, sir. If it survives, they will then seek review.
Yes, Lord.
Counsel the petitioner states that he has no instructions, dismissed. All right.
Item 98.
None appears dismissed.
Item number 99.
I may please your Lordship, I am appearing on behalf of my learned senior. Lordship, this matter is covered by the Narottam Ratha judgment, Your Lordship.
All right. Same order. All right.
Much obliged, Your Lordship.
Item number 100.
May it please your Lordship, appearing on behalf of Mr. P.K. Behra, allowed no instructions, madam.
No instructions.
Lord, liberty may be given.
Appeal for the opinion number 5, Your Lordship.
Lord, liberty may be given if cause of action.
No, there are no instructions. There are no instructions.
Obliged.
Weekly list item 101.
Petition is challenging part of the order of the Industrial Tribunal, where the London Tribunal directed the reinstatement, but denied the back causes, my lord. In this case, a notice was issued.
No. Have you got reinstatement or not?
My lord.
Have you been reinstated or not?
Yes, ma'am. We have reinstated, but back causes have not.
Reinstated since last 8 years.
Yes, ma'am.
You're working.
Yes, ma'am.
But
back causes has been denied.
How many years did you work before your termination?
We are working from 94, my lord. Thereafter transferred in 2007. And thereafter we are debarred from service. After on order of the London Tribunal, we have been reinstated. But back purchase has not been given, my lord.
AD not back from opposite parties 2 and 3. You're working there, sir. You should be able to serve. Whom are you working with? There are 2 opposite parties. Libra Exporters is one, AI Champadani.
We are working under Libra Export Limited. Open or 2 mile.
Then why couldn't you serve? You're working there only. You should have been able to serve by now.
Notice
that notice has been a notice to opposite party number 2 and 3 have been returned with remarks. No, the AD is not back from opposite parties 2 and 3. None is appearing on their behalf. No, there is one Sanjay Kumar. Somebody was appearing. Just see the Vakalat Nama. I see. None is appearing for the opposite party. See that none is appearing for opposite parties 2 and 3. Fresh notice be served Dasti. Returnable on 1st May 2023. Not 1st May, say 8th May. No, not even 8th. 9th May. 9th May.
Item 102. Two. 102.
Man appears dismissed.
Item 103.
103 and 104 covered by your lordship judgment in Narottam Ratha. Without jurisdiction, ASO passed the order.
Narottam Ratha.
103 and 104 both.
All right.
105.
In fact, your lordship, this is a matter pertaining to single bench as per roster. Matter that I have challenged the order of the appellate.
Single judge matter. Single judge.
In fact, as per roster, it is a single judge.
Then let it go. See, list before the roster bench will learn single judge. On 3rd April.
That interim order to continue.
Interim order to continue.
Then 106.
None appears dismissed.
Item 107. Sorry. It's gone. Today it is taken. Item 108.
Lordship, item 108, 109 and 118 covered matter, my lord. Order of ASO, Narottam Ratha.
108, 109
and 118, 118, my lord.
Item 110.
My lord, matter is cancellation of lease. My lord, same order.
Your sale deed is earlier. What is the date of your sale deed?
Purchase land 1991.
Yes, but prior to.
All right. Considering that the petitioner purchased the land in question from the original lessee by a registered sale deed that predates the impugned order dated 18th June 1998 of the Tahsildar Bhubaneswar. Additional Tahsildar Bhubaneswar. And it was passed, I said, impugned order was passed without notice to the present petitioner. It is hereby set aside and WL case number 349 of 1985 is restored to the file of the additional Tahsildar, where it will be listed for directions on 3rd April 2023. On that date, the petitioner will appear along with a downloaded copy of this order. The additional Tahsildar will proceed to hear the parties, including the petitioner, and dispose of the said case afresh within a period of 4 months thereafter. Till such time, status quo as of today shall be maintained. The writ petition is disposed of in the above terms. A copy of this order be sent to the additional Tahsildar Bhubaneswar forthwith.
Item 111.
None appears dismissed.
Item 112.
None appears dismissed.
112, 113 and 114.
Memos are taken on record. No instructions dismissed.
112 and 112, 113, 114. All three. Item 115.
That is covered by your lordship's judgment, my lord. Narottam Ratha ASO order.
All right.
Item 116.
None appears dismissed. All matters.
Item 117.
And I am for the opposite party number 46, my lords.
All right. None appears for the petitioner. Dismissed. For non-possible.
Item 119.
19. None appears dismissed.
Item 120.
None appears dismissed.
Item number 121.
Memo taken on record. No instructions.
Item 122.
22, my lord, in this case, sole petitioner died. So, substitute.
No, but you filed a substitution.
But
When
some
did he die?
time we required for substitution because his legal heirs are staying outside country, my lord. Therefore, some time.
Is anyone staying in the property?
My lord, that property that was leased out in favor of the petitioner and under Government Grants Act as Javan, my lord, because as rendered more than
No, but
5
is anyone
years of
staying
time.
there?
That was cancelled. That is before this honorable court. This honorable court set aside that cancellation and remitted back to ADN that to reconsider whether that lease has been granted under that lease principle rules or under Government's Grants Act. So that is already the notification is there, my lord.
No, but now this.
So that entitlement has already been decided by this honorable court. But this has already been cancelled again, my lord. When, my lord, that under OGLS Act, ADM has no power. That is that already settled. I have already given, but a substitution is required in this case. Therefore, I am not.
No, who's occupying? If everybody, all his children are abroad, then who's there in the property?
And Millards, this was given for a specific farming, Millards. Millards may see my counter affidavit. 17th of
I have
March
submitted my
2015. My lords.
note, my lord. I have submitted my note.
Para
with the
15,
date
my
chart.
lords.
In that, my lord, two decisions I have relied upon that this honorable court had already held that under section 7A3 of OGLS Act, ADM has no jurisdiction because this release has been granted under, my lord, Government's Grant Acts, read with some government resolutions are there, my lord. Under that act, so ADM has no jurisdiction, my lord, for cancellation. That is, your lordship 2010 OLR, I have already submitted a note, my lord. Your lordship may kindly see the decision. Sole petitioner died, that for my lord.
Under the Government Grants Act, who will have the jurisdiction?
Government's Grants Act, my lord, your lordship kindly see the orders, my lord, that this honorable court call for instructed the government to, my lord, produce a resolution, government resolution. that as per government resolution, one resolution has been produced before this honorable court, that is must have been with record, my lord. That 18/4/1980 resolution that is in Odia, in that resolution in Odia, vernacular language, my lord. In 78, lease was sanctioned, twice cancelled, twice, my lord, third round of litigation before this honorable court. So twice, my lord, this honorable court quashed the cancellation order.
You're still not answering the question.
Your lordship, I kindly say that will more clarify the fact, your lordship, Annex 13, your lordship kindly say, Annex 13, page 39, this honorable court's order. Annex 13, my lord. Page 13, page 39, your lordship, the relevant para, page 49, kindly see, para 10. That entitlement of the petitioner has already been decided. That he is entitled to only their allegation, government's allegation, that the lease has been, condition has been violated.
Okay, I'll just ask you one more time. If you pretend that you do not understand the question, then I cannot do anything. All right.
Your lordship, sorry, my lord.
Who is occupying the land today?
Today, petitioner is in possession.
Who said petitioner is expired, madam? Are you taking back that submission you made? You started off the case saying that the petitioner is expired, unless we have heard it wrong. What you told us was the petitioner is expired and all his children are abroad.
Your lordship, that their legal heirs, some of the legal heirs are staying in India and others are in outside.
Still, you're not answering the question. Still, you're very... See, I don't know why, what you gain by not answering the question directly. Honestly, if you have to say, I do not know, I will find out. You're taking a chance. You're saying some are in India. The question is, on the plot in question, who's there now on the ground?
My lord, the petitioner is in occupation. But before death of the present petitioner, my lord, he was occupying the set.
Madam, if you don't know, why did you say you don't know? Why are you guessing facts?
Then in the meantime, my lord, I have not obtained instruction.
So why don't you say that? Why are you guessing facts?
Your lordship, in the meanwhile, my lord, I have no instruction.
You first find out. Tell us who is occupying the plot. Give us the name of the person occupying the plot.
Power of attorney holder has filed this case.
Then which means the real person is not there.
Your lordship.
See, the truth is coming out now.
Your lordship. After death of the original.
You give us an honest statement of who is exactly occupying the plot and in what basis.
Your lordship. I'll abstain.
It will stay on board. This is again a Bhubaneswar land.
Yes,
Your lordship.
And you also tell us what is the market value of that land now.
Your lordship.
Let's get honest about the whole thing. Yes.
123. 123 instructions, my lord. 123
instructions. Dismissed as instructions. All right.
Item 124.
I am for the opposite.
None appeals for the petitioner dismissed.
Item 125.
My appearance may be noted for opposite party.
लिस्ट भी नहीं लिस्ट तो दोनों कौन बैठ
Item 125.
Where for the opposite party उन्होंने भेजना है.
Correct. None appeals dismissed.
Appearance was noted, man.
Item 126 to 133 already taken up.
126
to 133 already taken up.
already mentioned, my lord.
Item number 134.
One 134 now. The petitioner is impugning Annex 15 and Annex 20.
Worship, in item 134, I am appearing for the opposite parties. My learned senior, I had informed him from Monday itself that we have filed a counter in this case. It has not come up on board. So I just maybe given 2 days time to bring up the counter on board. From Monday, I have informed my learned senior. The Bhubaneswar Idco property.
Status quo.
The status quo was till 2017.
No, status quo never been vacated. At least in our records, it's not been vacated.
But it
was only filled the next date and then not extended. What is your instruction? What is the client doing? Still there?
My instruction that is he's still in possession of the.
No. What is happening on that land?
Nothing, my lord. Because
vacant land.
His hard construction was there after the cancellation of the lease. Then he has not progressed any further.
My God. So it's just vacant land there.
Lordship, then they can apply afresh also.
If it's vacant, you apply afresh, sir.
My lord,
ask them to take a decision within 4 months and the status quo will be maintained.
Your lordship,
what was it cancelled for? Because you didn't pay the installment.
No, my lord.
My lord, or you did not build the industry.
Did not start within the stipulated time.
My lord, may I present the small fact, my lord, which will be convenient, my lord. The lease was granted in the year 2001. The consideration amount was of 5,91,000. The lease was valid till 2068. The two prime conditions were there. that I need to start the installation within 12 months of getting possession and thereafter to commence the production within 2 years. I got the possession in the year 2006. That is towards the end of 2006, after 6 years. Then immediately within 10 or 11 months, they sent a so cause notice that why you have not started construction. And then and when I filed this so cause, I said that it's because of your latches, 6 years possession you have given, and hardly I have got 5 or 10 months. 10 months. So accordingly, I submitted my so cause. Instead of that, they cancelled it. I appealed it. In the appeal, it was the cancellation order was revoked. And I was given a fresh second start that you can start it by 31/12/2008. There is a fresh given. I was given a fresh opportunity to start it. Then then I submitted my plan because no time was given to me. I submitted my plan, and till date, my plan is still has not been approved. I have been giving them representations to please give me the plan, approve the plan. They have not sought, and they have given me shortcomings, and I have also amended the shortcomings and I have given a revised plan. All these are there. Instead of that, they have cancelled it, and it is merely because of the latches of the of the IDCO, I am unable to construct anything. And now they say that you have made some construction over there, so that's why you are cancelling it. The cancellation order is in Annex 15, page 51. That is the reason they have given. Thereafter, again, they said that let there be an inquiry. An inquiry report is there in page 56. Page 56 clearly says that I have not violated any condition. Annex 18, my lord. This is their report, status report. Page 56, serial number 12.
You have a copy of your counter?
Lordship, it's not.
Bring it after lunch. Let's see the counter.
That's why that is the difficulty, Lordship. I have informed that I am not be able to trace it. So old matter, in all matters, usually my counter is on board.
No, my lord, I have not been supplied with the counter.
A long time has passed. They may apply afresh. We will consider.
Well, I will go through the same rigorous procedure, my lord. If they approve my plan, that will it will resolve their process, my lord. My plan is still there with them.
They were deleted from the approved
plan.
We have encroached
The status report clearly says.
I have status report. Is in there?
Yes. Serial number 12, my lord.
Misutilization, no. Whether construction plan approved or not, no. Oh, you have to approve it from the BDA. See, para 12, just see that, no. Page 56, column 12.
My lord.
Unit had submitted the plan for approval to IDCO. The unit was intimated to take back the drawings and get the same approved by BDA.
My lord. This is the first time we learned about this. We have to get approved because as per the agreement, we need to get it approved by the IDCO, and the shortcomings are also there in page 43. What the plan had shortcomings, that is by through the.
So anyway, you have to get it approved by the BDA.
My lord, if it is to be approved by the BDA, my lord, we'll file it, my lord. The plan is to this particular plan, but it has to go through the IDCO again, my lord.
That's right. You get it approved with the BDA and submit it to them, then they'll consider it.
Yes. Till then, my status quo.
It's BDA party now that we have to see.
No.
If it can be called 1 week later, I'll clarify everything in my counter. It is very clear counter affidavit.
All right, stay on board. It will come on Monday now. Stay on board.
Okay.
All right.
Tuesday, Monday.
Whatever. Whenever the court sits next. After lunch? After the phone.
Grateful.
Other side a copy. Mr.
Yes.
Rathur.
Weekly list, item number 135. Weekly list item number 136.
My lord, the petitioner seeks to assert the award dated 20th November 2014 of the learned presiding officer Industrial Tribunal Bhubaneswar passed in industrial dispute case number 28 of 2008, answering the industrial disputes reference against the petitioner workman. The tribunal grossly and willfully overlooked and ignored the most vital fact of the relating to the termination of the petitioner workman from service by the opposite party number 1. Attract the mischief of section 25F of the Industrial Dispute Act. The petitioner was appointed clerk cum typist in the college public institution. The opposite party number 1 had order dated 21/3/95 and working till 31st/6/2001 and orally terminated in 1/7/2001 without complying any condition of section 25F of the Industrial Dispute Act. In the reference, the opposite party is also not present. The petitioner submitted her grievance before the district labor officer Mayurbhanj, who initiated the conciliation. Conciliation failed. The opposite party was not appeared before the labor officer. And then ID the Industrial Tribunal Bhubaneswar had his letter dated 14/7/23, dated 30 April 2008, referred for to dispute for adjudication. The opposite party number 1 terminated the workman not complying any condition of section 25 of F, orally terminated, no 1 month's notice or compensated or
You're not able to prove that you were appointed by the college at all. What are where are the documents?
Para 13 of the writ petition.
Not writ petition, come to the award, madam. Come to the award.
Submitted her evidence affidavit and additional.
Come to page 32, internal page 6 of the award.
Page 32.
32.
W to the then president.
On close scrutiny. Just read the para which begins on a close scrutiny. Page 32. On a close, second paragraph.
On a close scrutiny, exhibit 1, it is seen that nothing has been mentioned there on to give a slightest indication that the letter was issued by the secretary of the management of the college towards appointment of the second party. As a clerk cum typist, if the contents of the letter is accepted in toto, it is divulging that the second party was instructed to meet the scribe the letter as soon as possible. Similarly, exhibit 2 reveals that 18,000, the donation amount from one Kunja Bihari Das. Kunja Das as donation is the then secretary, as donation for development of the college. There is nothing in the written statement. The opposite party number admit that he was joining in the college. He is not adduce any evidence himself, and one Basant Kumar Bari, working as a clerk cum typist of this college, who has never proved as he was a workman, deposed on behalf of the opposite party number 1. But the petitioner submitted his evidence affidavit, additional evidence affidavit, and examined herself. And Khogeshwar Mahakul, who was also a workman, and the Vasudev Shah, the then president of the college, deposed in favor of the petitioner.
There is no document to show you were ever employed. Even your attendance register, you were not able to produce.
Sorry. The opposite party did not produce any document.
You did not produce. You have to first show that you were working in that college.
Enrollment.
They have denied that they ever employed you.
95. (21st/3/1995). The exhibit 1 is proved by the evidence led by the opposite party. The witness for the opposite party number also deposed that the petitioner as appointed as clerk cum typist in the college of the opposite party number 1. And also in the written statement, the opposite party stated that the petitioner was appointed as clerk cum typist.
No. They denied it. They've throughout denied that you were even appointed.
See. He stated that this is the exhibit 1 is the appointment letter. And exhibit 7 is the letter of the principal for the duties of the staffs. In exhibit 7, his name was mentioned in that charge. Remain in the routine attendance and staff and students. His name is Urgent along with the
you come to page 33. There's a discussion of this.
33, para 2. The other document on which the second party is happening much to establish a relationship with the college as an employee is exhibit 7, which is perpetuated Xerox copy. It is general, sir.
Read the whole thing, madam.
Copy of the order of the principal assigning duties to the staffs, and in said order, the second party along with 4 others, including the who is led evidence on behalf of the managing committee.
Madam, if you stop reading like this, you will be in trouble.
The second party along with 4 others was assigned the duty to remain in charge of routine attendance and staff and students. In this connection, it is pertinent to mention here that this piece of document was not produced before this annual till 16/10/2014, when on recall petition, the second party was examined and got exhibited the document. Now, additional affidavit file examined and got exhibited the document on being cross-examined. She is also not able to explain as to why the document was not relied upon and filed earlier. In such view of the manner, it cannot be ruled out that it is a on lateral document, and for that reason, no reliance can be placed on. There is a stamp and sign of the principal in this letter. He is not appear before this court also. Sir, please next week I will satisfy it.
No. So the challenge of the present petition is to an award dated 28 November 2014, passed by the Industrial Tribunal Bhubaneswar.
Then next week I will satisfy.
Industrial dispute case number 28 of 2008. answering the following reference made to it against the petitioner workman.
Sir, next week I will submit this.
And reproduce the top of page 28 paragraph. The case of the petitioner was that she had been engaged as clerk cum typist by the opposite party management by an appointment order
Manager already
31st March
admitted with written
1995,
submission.
and that she had, as a condition for getting such appointment, deposited 18,000 with it. Full stop. She claimed to have been working continuously with the management from 21st March 1995 to 31st June 2001, and further claimed that all of a sudden she was refused employment on 1st July 2001. Full stop. She claimed that the termination of her service was contrary to Section 25 of the Industrial Disputes Act 1947 Bracket Act. Full stop. She claimed reinstatement with full back wages. Paragraph. Apart from contending that the petitioner was not a workman within the meaning of Section 2 bracket small s of the Act, the management denied
Management
that
accept in
the
his
petitioner
written
was
statement.
ever engaged as clerk cum typist. Stop. According to the management, she did not join pursuant to the letter issued to her, and therefore there was no question of refusal of service. Stop. It was also denied that any money had been deposited by her as a condition for appointment. Stop. Paragraph.
Written
One of the
8,000
questions,
written
one of the first
8,000.
issues addressed by the Labour Court was whether in fact the petitioner had been appointed as typist cum clerk in the management. Full stop. In support of a claim, the petitioner produced as Exhibit 1 the letter dated the 21st March 1995, and Exhibit 2 purporting to be the receipt issued by the Secretary of the College for the sum of rupees 18,000. Full stop. Apart from examining herself as a witness, she also examined a former president of the management of the college as WW2, who stated that she had been appointed and joined the post of clerk cum typist and was working as such from 21st March 1995 to 30th July 2001. Paragraph. The Labour Court, on carefully examining the exhibits, found that Exhibit 1 only showed that the workman was instructed to meet the scribe of the letter as soon as possible. Full stop. It nowhere read as a letter of appointment. Full stop. Paragraph. As regards Exhibit 2, the receipt was in favor of one Kunja Bihari Das, and stated that the money was donated for development of the college. Full stop. There was nothing in the said document to indicate that the deposit had been made on behalf of the petitioner as a condition precedent for appointment as a clerk. Full stop. The remaining exhibits 3 to 6 did not relate to the petitioner working as a clerk with the management. Full stop. Paragraph. The petitioner then relied on the Xerox copy of an order of the principal assigning duties to the staff, which included the petitioner. Full stop. The Labour Court noted that, the tribunal noted that this document was not produced earlier by the petitioner. Full stop. She filed a recall petition and got the document exhibited. Full stop. She was unable to explain how the document was not produced earlier. Stop. Accordingly, the tribunal chose to disbelieve it. Paragraph. Importantly, the tribunal noted that the attendance register should have proved that the petitioner was working with the management, was not asked to be produced by her. Full stop. In other words, no material is placed before the tribunal which could substantiate the plea of the petitioner that she had worked for the management. Full stop. Accordingly, both issues 1 and 2 were answered against her. Paragraph. Having heard learned counsel for the petitioner, the court is not persuaded that the tribunal has committed any error in coming to the above conclusion. Full stop. Even before this court, no document has been shown which would demonstrate that the petitioner was in fact working as a clerk cum typist to the management between 21st March 1995 and 30 July 2001 as claimed by her. The award of the tribunal being purely on facts and the conclusions being drawn on an analysis of the evidence led by the parties, the court is unable to find any error therein which requires interference. Full stop. There is no merit to the present petition and it is dismissed as such.
Item number 137. Weekly list 137.
None appears dismissed.
138.
None appears dismissed.
Order 138. I'm on behalf of Mr. S.K. Patnaik. It's a copy, counter copy, not supply, opposite 2 and 3.
Counter copy. Yes.
What is the matter about? What are your prayers?
Lord, illegal acquisition of the land of the petitioner.
When was it acquired? That's not the prayer anyway. Yes, sir. Carry on. Tell us what his case is about.
Paragraph 5 of the counter affidavit. We have given the
asking him.
details.
Without valid documents.
Without counter.
There are already encroachment cases against you, sir.
Only thing is that he is claiming that I am a royal. Our stand is that he is an illegal occupier.
Correct.
And that is the only
No documents are produced.
Yes. There is no rejoinder to that also. And the record of right reveals that in the remark column, he is shown as under beain dakhal, that is illegal occupation.
My lord, a copy of the counter.
You make out your case, sir, then everything will come. You make out your case. What is your case?
And I'm on behalf of Mr. S.K. Patnaik, who's on ill. I'm on behalf.
All right, he'll stay on board. All right. You'll be called out on Monday, sir. Ask him to come.
Monday, man.
You give him a copy of the counter now only.
Item 139.
In this case also, no, I have not received the counter, my lord. And a matter relating to it is the villagers approached before this honorable court for a direction to the opposite party to settle the land as per their actual position, my lord. In this case, my lord, due to high flood and change of riverbed, the entire village has been was inside the river Boitrani, my lord. Thereafter, the villagers prior to 1929 shifted to irrigation land and resided there. But, my lord, Annexure 4, my lord, page 59, the Tahsildar, as per the direction of the collector and the government, inquired the matter and found out that the long prior to 29, the villagers resided over the irrigation land, and as the land belongs to irrigation, it is not possible to settle the land. Thereafter, my lord, as per the letter of the collector, Annexure 5, and the joint inquiry report, Annexure 6, my lord, the government irrigation department, by Annexure 7, page 75, my lord, the relinquished 5 acre 59 decimal in favor of revenue department to settle the land in favor of the inhabitant of the villages, my lord. Thereafter, my lord, the Annexure 9, page 77, the Tahsildar seeking clarification regarding how to settle the land in favor of the villagers, seeking clarification whether criteria of homesteadless landless shall be taken into consideration while settling the occupied land in favor of the person concerned, whether premium as per the prevailing market rate shall be levied on those occupants while settling the land, maximum extent land to be settled in favor of the occupant. Thereafter, collector also, by the Annexure 10, seeking clarification to the government. In this case, prior to 29 settlement, since 100 years, the villagers...
Actually, the counter affidavit supports the case. You say you've released the land for the settlement in their favor.
We have identified 43%.
45%.
Extremely, sir. Because we have identified about 46 persons whom we say that the land should be settled. But there was a clarification sought by the Tahsildar that I don't have instructions. I'll seek instructions if that clarification, which my lords will find in my.
46, 15 are eligible.
Because the others are all illegal options.
Copy of the counter affidavit filed by opposite parties 3 and 4 be served on counsel with the petitioner today itself. Counsel for the opposite parties 3 and 4 seeks time for instructions on the progress of settling the land in favor of the 15 eligible occupants as contended in the counter affidavit. List on 27th April.
And 27 January.
April. Item 140.
And in the winter, counter, sir.
Yes, I'm talking right there.
140, I'm appealing for the corporation.
None appears for the petitioner. Dismissal numbers.
Item 141.
None appears dismissed.
Item 142.
None appears dismissed.
Item 143.
None appears dismissed.
Item 144.
None appears dismissed.
Item 145.
145, my lord. Here the petitioner challenges the cancellation of the allotment under Annexure 12 by IDCO, a cryptic order at page 64. Please refer to this letter number so and so regarding breach of terms of allotment We have received your reply in response to our show cause notice. Reply is not satisfactory. You have violated the terms of undertaking agreement. You have not used. The reason is you have not utilized the plot for the purpose for which it was allotted since long, thereby violating clause 16 of allotment letter and so and so. This was challenged in appeal at page 74. A non-speaking order was passed at page 74. The appeal is rejected. But here, the question, the allegation is that I have not utilized the plot for the purpose for which it was granted. Now, your Lordship may see, I have given a date chart, relevant dates. Lordship got it? No.
Yes.
Achi. Second copy.
Tell us.
Yes. Your Lordship may see just few dates I am placing. 23/4/99, IDCO allotted IDCO plot number so and so in favor of the petitioner for setting up a hotel. Then 11/1/2000 possession was handed over by IDCO. 31/10/2002, IDCO cancelled the allotment.
What was the condition of allotment? Within what time had you to raise construction?
No, that is why I bring to your Lordship this notice, because they have a clause that they have to give an NOC to procure a loan from the bank.
In this allotment letter,
yes, Lord.
What was the condition as far as setting up of the hotel, building the hotel is concerned? What is the condition?
Hotel. For construction of hotel.
Read out, sir. Read out from the relevant portion. Which page?
My lord, page 2.
Annexure 1.
Page 23, my lord.
Page 23, annexure 1.
Let's read that.
Not page 23. It's page
You will
21.
have to start
Page 21.
16, clause 16.
Page 21. With reference to your application so and so dated, so we hereby allot plot number so and so.
Come to page 23, clause 16, sir.
Yes, Lord. Lordship may see. 23 clause C. You'll have to start civil construction on a plot within 6 months and utilize the plot and start commercial production within 2 years from taking over possession. So therefore it was cancelled. No, this cancellation has been revoked. That's why I'm placing those dates. Lord, this 31/10/2002, this allotment was cancelled, which I'll refer to your Lordship. Annexure 1. Intimation of UU case number so and so before there. This is important. 10/10/2003, the estate officer passed the order, allow them to go ahead with construction during pendency of the cancellation proceeding. Then 2003, I constructed the boundary wall around the plot at huge cost and developed land with ancillary constructions, borewell for water supply, electricity connection obtained, drawings and plans. This is important. Drawings and plans submitted to IDCO for approval. IDCO, after 2 years, directed amendments of the plan. Planning manager forwarded plan to BDA for approval. Submitted necessary documents as suggested by BDA with requisite fees. Received approval from Fire Office, that is July 2010. Then on 13/10/2010, revocation was cancellation order was revoked. That previous cancellation order was revoked after 8 years. Then 7/10/2010, lease deed was executed. This is the clause which I was referring to. Lessee with previous consent in writing of the lessor can assign or transfer his interest in the property in favor of any scheduled bank, financial institution, LIC for securing loan to be advanced by them. So in order to get finance, I have to get their NOC. So this started communication with BDA. BDA directed 29/4/2011, BDA directed payment of 31.5 lakhs. Then BDA's approval was received on 15/10. Executive engineer IDCO was requested for submission of documents for techno feasibility report forwarding to the bankers, because bankers needed NOC from as per that clause. Receipt of techno-economic viability report in 2012. Proposal to PNB and SIDBI Bank for financial assistance. This the IDCO themselves gave. PNB forwarded letter to IDCO for NOC, no objection, application of mortgage. Then petitioner forwarded letter to IDCO for NOC. Registration of NOC chhado. Then 15/5/2013, the divisional head of IDCO submitted all papers before the manager for issuance of NOC in favor of the company. This is important. Then letter of SIDBI requesting company for NOC of IDCO. Request letter to Department of Tourism for provisional certificate. Then suddenly when this was going on, they issued the show cause notice. Again, IDCO issued show cause notice within 15 days for cancellation of allotment. I explained them that these are the reasons for which the construction could not have been completed. And without finance also I am unable to do. And the clause says that to get the finance is ready. But the clause says that you have to get an NOC from the IDCO. NOC did not give the IDCO. IDCO did not give the NOC to the bank. Therefore, and I had to spend a huge amount on it. I'm still in possession, my lord. I am paying the up-to-date dues as demanded, as on today also.
What is happening on the plot?
Pardon, lord?
What is the status of this plot now? What is it?
Construction. Construction is there. Construction is there because they permitted, the court permitted, the EO estate officer court permitted me to construct.
What have you constructed?
Status quo order is there. I have constructed. I have constructed substantially. The building has been completed.
Show us photo.
I can boundary wall.
Show us what is the substantial construction you have done. Show us that.
Your lordship wants the status of the construction.
Whatever we want to know, what is happening.
What is going on there?
Pardon?
Is it no? What is going on there?
No. Now it is not. Nothing.
Only construction is made, or something.
Boundary wall.
Activities.
Boundary wall and some minor constructions.
Activities.
Activities because
now you have toned down your. You said substantial construction. Now you are saying boundary wall.
Because
what is
the construction cannot be completed because of lack of finance. Because the NOC was not granted by the.
What's the point, sir? Even today, your position will be no different. What's the point?
No, now, if they give the NOC, my finance is ready. I will go and build it.
You have to start civil construction 6
months.
No,
civil construction start. They themselves have delayed the matter. What can I do? I cannot construct without their NOC. No? And the project is a huge amount. So therefore, it has to be dependent on the bank. And that is why there is a specific clause that you have to get a written consent from them. And they are not, because they are writing it that we are sending it, but they have not sent. Suddenly they give a show cause notice. And they have not considered why we have not considered constructed with anything. Lordship may see that two sides, Lord. We have invested the money, we have invested the money on the plot, and we have constructed the boundary wall and deposited the entire amount, 31.5 lakhs after we asked for NOC, they told that you deposit this amount, thereafter we will give you the NOC. So the amount was deposited. Entire amount was deposited, and now till date they are appropriating the rent also.
My lord, if I may, my lord, lordship may kindly see the lease deed that is at Annexure 6. At page 35, my lord. In the said lease deed, the clause 3, my lord, at page 37, it is clearly stated that the lessee shall have to start civil construction on the allotted property within 6 months from the date of possession and commence commercial production within 2 years from the said date, my lord. Now, my lord, may kindly see.
Thereafter, kindly read thereafter. For any construction, addition or alteration to the exit building and for additional construction, the lessee shall submit the building plans and take up the construction, addition, alteration, additional, only after obtaining approval of the. So this cannot be read literally that 6 months. There are some things have to be performed and NOC has to be given, finance has to be obtained. These are things which the parties were aware of and they had covenanted in the.
Not the plan. The The plan has to be approved by BTA, not IDCO, my lord.
Yes, I have submitted that. Your Lordship, kindly see for a moment Annexure 10, page 59. Page 59.
Yes.
But page 59, IDCO, on the caption subject, it is to intimate that the above mentioned unit has applied for issuance of NOC to avail financial assistance from Punjab National Bank, so and so. The application of the unit along with other requisite documents are enclosed herewith for the year for your information and necessary action. This letter they give on 15/5/2013, but on 21/6/2013 they say that you have not constructed and they have cancelled. Next page, page 60. They themselves give the papers. But on the next page, Annexure 11, they issue a show
What is the reply to 9.3, 9.4 in the counter? No reply.
There.
Just come to para 12 of your counter.
Yes, no.
Not answered this at all.
My lord.
You come to para 9 of the writ petition. (9.1), 9.2.
Yes.
My lord.
Do not reply to this at all. 9, 9.1, 9.2, 9.3, 9.4. Not replied to at all. 10 not replied. 11 not replied.
My lord, I can file an additional affidavit, my lord. Let it stay on board. I will file, my lord.
It is seen that among other grounds, the petitioner contends that it was not in a position to complete civil construction, start commercial production on the plot in question without NOC from IDCO. Full stop. In paras 9 to 11, averments of the writ petition, averments have been made in this regard, which have not been replied to at all by IDCO in its counter affidavit. Full stop. There is only one line in para 12 of the counter affidavit, which tries to deal with paras 9 to 11 together without dealing with the averments therein. Paragraph: counsel for IDCO seeks leave to file a supplementary counter affidavit specifically dealing with the averments in the above paragraphs. The said affidavit be filed within 4 weeks. Rejoinder thereto can be filed by the petitioner before the next date. Interim order to continue. List on the regular list on 10th August.
Item 146.
Well, all the petitioners are belong to the ST category. And while I have not received the counter, the sole prayer of the petition is that for the purpose of the minor irrigation project in the district of Nuapada under the Khariar block, the partly they have received the compensation amount. And now all the land is existing in the name of the petitioners. Opposite party number 2 not paid the compensation amount to the petitioners.
No reply file, nothing.
There's some time may be given.
You see, despite notice having been issued way back on 13th April 2015, no reply has been filed till date. Paragraph, the grievance of the petitioners is about non-payment of compensation for lands acquired for a minor irrigation project in Khariar. Full stop. A representation made by them is at annexure 3. Full stop. Accordingly, a direction is issued to the Special Land Acquisition Officer, Khariar, bracket opposite party number 2, to examine the said representation, bracket annexure 3, and after hearing the petitioners to pass a reasoned order, not later than 10th April 2023, and communicated to the petitioners not later than week thereafter. The date of hearing the petitioners should be informed to them at least 10 days in advance. The court clarifies it is not expressed anywhere in the matter. The petition is disposed.
147.
I'm appearing for opposite party, my lord.
None appears to the petitioner. Dismissal on prosecution.
148.
148, your lordship, petitioner has died and he has also made the payment, your lordship.
Constantly, the petitioner states that the petitioner is dead and also the cause of action does not survive. The petition is disposed of.
149.
None appears. Dismissed.
Item 150.
May I please, your lordship? On behalf of Mr. A.K. Pradhan, I am appearing in this matter, my lord.
Not pressed. Or
no, my lord. I am.
You are arguing. All right.
Yes, ma'am.
All right.
My lord, the petitioner in this case is the petitioner in this case is a lordship is director of this this SCG Trading Private Limited, my lord.
Which is the borrower?
My lord.
Which is the borrower?
Yes, my lord. Who is the director? It is the company is a storing unit.
Does matter spending the DRT or not?
My lord, matter already DRT auction already made, my lord. But
what is remaining?
My lord, my only prayer, limited prayer, my lord, that till date, from the date of freezing, till date there is no bidder, no one running the matter.
So nothing. There's nothing for you to worry about.
I am ready for the settlement, my lord.
You approach them. Say, constantly the petitioner seeks.
My lord, that liberty may be granted.
Draw the person petition with liberty to approach the bank for a proposal for settlement of the dues. Disposed of is withdrawn with liberty straight for audit.
151.
On behalf of Ms. Mahapatram, kindly taken up 2 weeks after the petitioner has been died and substitution has already been filed.
What is the prayer?
Prayer, sir, my lord, file is not with me.
It's with us. If you want, we can give you our file. We give her a.
Well, let me kindly pass it over. I will inform us.
Weekly, all will not serve the purpose. Recover compensation amount from opposite party number 3.
Opposite party number 3 and 4, I am appearing for. Opposite party number 3 and 4. The property was admittedly stood recorded, that is 67 decimals. The extent is 67 decimals. That was stood recorded jointly in the name of 3 branches. That is Chaturbhuj, Sankara and Sankar.
So it's a civil dispute.
Yes, sir.
Civil dispute.
Yes. Civil issue. Yes.
Yes. So section 30, they should have gone under section 30.
Kindly take note 2 more
disputes, right? With regard to right.
Quicker, it will be easier for you. We'll permit you to invoke section 30. You see, it appears that there is a civil dispute between the petitioner on the one hand and opposite parties 3 and 4 on the other as regards disposal of compensation.
Yes.
Full stop, such dispute has to be properly adjudicated in proceedings.
Common law forum.
Yeah, in the civil court.
This is National Highway Act.
Yeah.
This is National
Civil
Highway
court.
Act. 34 is not there. 30
All
is
right.
not- I mean,
In the civil court and not by way of the present writ petition.
Yes.
Leaving it to the petitioner to invoke other appropriate remedies as may be available to the petitioner in accordance with law, the petition is dismissed. Right.
Item 152.
I am for the opposite party number 4, madam.
None appears for the petition dismissed. On opposition.
I may pardon me, Lord. In 151, stay is there, may be vacated.
A stay is vacated.
Interim order may be vacated.
Interim order is vacated. All right.
Item 153.
Issue 153 pass out for the day mileage misplaced lordship. Says every day I'm
Stay on board. Stay on board. On Monday, if it's not there, then you know what will happen. Stay on board. All right.
Let's see.
154.
This is the covered matter decided by your lordship in WPC number 1608 of 2014, my lord. Regarding that assistant settlement officer rejected, my lord.
Same.
Yes,
Narottam Ratha.
yes. 154 and 155, my lord.
55. All right. Both. All right.
156.
None appears dismissed.
My lord, I'm there, my lord, I'm on virtual mode, my lord.
All right. All right. Tell us.
My lord, the issues which are falling for determination in this writ petition are to be decided by the Commissioner of Endowment in the pending RC number 31 of 2018. That liberty may be granted.
Right.
And
Counsel of the petition seeks leave to withdraw the present petition with liberty to raise the dispute in the pending in the pending matter, namely
Annexure 1213. Pending RC revision, RC 31 of 2018.
RC 31 of 2018.
And RC 2 of 2019.
That's all right. Pending before the Commissioner of Endowments.
Madam.
Disposed of is withdrawn with liberty is prayed for.
Deep.
Item 157.
None appears dismissed.
Item 158.
May I please, your lordship? My lord, here I have challenged the order passed by the assistant settlement officer. That is at
not covered by Narottam Ratha.
No, my lord. Here, my lord, the lease was granted in favor of one Jaladhar Maji. After taking permission from the oiler authorities, he sold the land in the year 1981 in my favor. I got it recorded in my name. When the settlement operation started,
you are not an ST.
No, I am not an ST. But when the settlement operation started, I filed objection to record the same in my name. Now, my lordship, have a glance the order passed by the authority. They have stated that it is a printed order. Only page 28 is the relevant portion of lordship, have a glance. It has not been recorded in favor of the petitioner on the ground that he did not use the land for which it was leased out. So here the question of lease is not there because the lessee has already sold the land in my favor since 1981 with due permission of the boiler authorities.
Here the purchaser was heard. The original lessee did not use the land for the purpose it was granted to him. And that is why this order was passed. He is not liable to use the land for the purpose for which the lease is.
But with permission, suppose he purchased the land and
yes, permission. He is saying that under the OLR Act, he opted permission for sale. That is for sale. But while deciding the legality of the lease deed, this condition has been violated. Appears to have been violated. That is why the order
finds out.
Sale how?
No, sale. Even if the sale deed is there, if your vendor has violated the lease condition, the authority is entitled under the law.
When?
After hearing the purchaser.
When did the sale take place?
No, he is not the authority, my lord. The person who has passed the order is not the authority. The authority is under the OGLS Act. Here, my lord, the settlement authorities have said that.
Narottam Ratha Kawa said that.
Then why are you not saying that? That is.
Perhaps
Narottam Ratha.
he is not aware of that. He may not be aware of that.
All right.
Sorry.
2nd January order.
Oh, my lord. I will.
All right. Narottam Ratha. All right.
159.
May I please, your lordship?
May I please, your lordship. In this case, the petitioner challenges the inaction of the opposite party is not granting lease in favor of the petitioner, my lord. While the matter was in hearing the list, the direction given by this honorable court to consider the grievance of the petitioner and pass necessary orders as per the writ disposed upon writ petition number 23437 of 2012. While the matter was taken up by the lordships, my lord, at that point of time, the honorable counsel appearing for the state submitted that they have considered and rejected my prayer, and they have not given me or intimate me the copy of the rejection order. When I came to this, my lord, while the hearing was going on, I was supplied with the copy of the rejection order by the state council in the court, my lord. After coming to I have filed an amendment application to my writ application, which is before your lordships, my lord. I have filed an amendment petition for
10348.
Pardon, my lord?
10348.
Yes, my lord. Yes, my lord. And
this if your application 10348 of 2022 for the reasons stated therein, this is not scanned. The application is allowed. Then the main petition, the amended consolidated writ petition. You have to file that.
I will file them within 3 days, man.
Filed within a week. Reply to the amended petition be filed within 4 weeks, rejoined the next day.
They have not filed any counter or
better, because after amendment we will file a better counter.
Hearing stays through SHG Pune, na?
10th list.
Oh, bless.
My lord, regular list.
10th August. Item 160.
Non-appeals list.
Item 161.
161, my lord, I may be permitted to withdraw with the liberty to approach the OP number 1, my lord.
All right. The petitioner seeks leave to withdraw the present petition with liberty to approach the secretary, state level single window clearance authority, government of Orissa, in accordance with law disposed of withdrawn with liberty paid.
162.
Today I have been. Today I am appearing for the petitioner, and the brief has been introduced today. Lordship, give 10 days time. I will come back to your lordship.
Stay on board, sir. Not 10 days. Monday you get ready.
Your lordship.
All right.
Interim order to continue, man.
Nothing. Staying on board. We're not passing any order.
Yes, sir.
Item 163.
Well, I please your lordship. Well, in 163, petitioner number 3 has expired, my lord, in the month of December, my lord. So I have to make a substitution.
What's the matter about, sir?
Well, that is challenging the order of the Board of Revenue, my lord.
Right. Counsel for the petitioner states that petition number 3 is expired. And his LRs have to be brought in record. That is request. List on.
Petitioner 3, Gaurav Kishore Mahanti, my lord. And also in the opposite party, in the 3 in the first brief, my lord.
All right.
Item 164.
On behalf of Mr. Patnaik, senior counsel is ill today. Let it be taken next week or any other.
What's the matter about, sir?
164, my lord.
What is the matter about?
Matter, my lord, I have not got the file. Mr. Counsel arguing senior counsel, Mr. Patnaik is ill. Let BSNL matter, my lord.
Stay on board.
My lord?
Will be on board.
Yes.
Item 165.
165, my lord, no instruction.
No instructions dismissed.
166.
None appeals dismissed.
167.
None appeals dismissed.
167.
168.
Your lordship. Lord, in this case, my lord, the petitioner has challenged the order under Annexure 1 that passed by Jagannath Temple Chief Administrator, my lord, that I was in occupation of land by virtue of permanent lease deed since 1938. Thereafter, after my lord, formulation of uniform policy in 2003, my lord, I have applied for the same, being position over the same, that has been rejected. That your lordship, the temple probably not there, but he has filed a counter that this is applicable under section 24(1). So your lordship may
Constable, the petitioner seeks leave to withdraw the present petition with liberty to file an appeal under section 24(1) of the
Sri Jagannath Temple Act, my lord. Sri Jagannath Temple Act,
Sri Jagannath Temple Act,
1954.
Sri Jagannath Temple Act 1954. 55.
Yes.
Accordingly, the petition is disposed of is withdrawn with liberty as prayed for. If the appeal is filed not later than 1st March, accompanied by an application for condition of delay, citing the pendency of the present petition as the reason for the delay, it will be considered in accordance with law by the appellate authority. If the appeal is filed within the time stipulated, then till such time the appeal is disposed of, the interim order passed by this court on 24th December 2015 shall continue. That petition is disposed of is withdrawn with liberty as prayed for in the above terms.
169.
Your lordship, only a grievance, my lord, that since 24/12/2015, there is a status quo order because I am in position.
That is that, madam, you're not listening to what...
In fact, he is not in position. That's why it is rejected under the policy.
169.
169. In this case, my lord, the petitioner has challenged the order under Annexure 1 issued by IDCO. That allotment, lawful allotment made in favor of the petitioner since 1978, my lord, 2 plots, additional plot A41 and 42. That has been, but before that, my lord, I want to submit that I was in a position over that property by virtue of that allotment since 1978. Thereafter, in 1980, when IDCO Act enacted, then IDCO has executed a lease deed with the petitioner in 1982. Thereafter, my lord, your lordship, there is an agreement, clause 5 of the that agreement that is pertinent for this purpose of this matter, my lord, that is without approval of IDCO, this petitioner that allottee cannot transfer to any third party, my lord. So without approval. So therefore, my lord, since gradually, my lord, to mitigate my financial stringency that has decreased, my lord, therefore, my lord, I executed an agreement with OP number 7. Thereafter, my lord, due to non-cooperation of that OP number 7, that I have again filed an application before IDCO for withdrawal. That withdrawal was accepted by IDCO. Now, thereafter, but your lordship, I have prayed for IDCO that due to non-cooperation and forcibly possessed by OP number 7, I filed an FIR before IIC and DCP that has not been, my lord, acted upon. Therefore, my lord, your lordship, ultimately, IDCO authorities itself also filed an FIR that is on record, my lord, filed an FIR, and the Chamber of Commerce, my lord, that also filed a grievance petition before DCP for eviction, because as per law, the lessee is bound to put possession the lessee as per section 108. Therefore, ultimately, your lordship kindly turned to, I filed writ petition. In writ petition, this order was passed. Your lordship, page 1. I have quoted that order. Your lordship kindly see. That your lordship, page 13, man. Kindly see. Page 13-15 for 2014, this writ petition was disposed of. This writ petition earlier filed by the petitioner for inaction of IDCO authorities for eviction of that OP number 7 from the allotted land. But your lordship, that 2 plot was allotted, but the agreement was executed in respect of 1 plot. But Annexure 1, the impugn order herein, my lord, that was first, my lord, in cancellation by both plot, my lord. Then your lordship, I have quoted that order, your lordship, kindly see, WPC number 13-13284 by 2013, filed by petitioner number 2, fraying for a direction to evict the proprietor of OP number 7 from active premises or dispose of with the following direction. Then that is quoted in page 14, your lordship. This writ petition has been filed challenging the inaction of chairman cum MD IDCO OP number 2 in not taking effective step to evict OP number 4 from the industrial shed number A by 41 and A by 42 in the industrial estate. Because, my lord, agreement was executed in respect of A by 41, but forcibly, my lord, OP number 7, my lord, possessed both the plots. Therefore, my lord, in the industrial estate, which was allotted to the petitioner, it is stated that in this regard, a representation has been submitted to the said OP number 2 dated so and so as per Annexure 8, which according to the petitioner is pending consideration. Without going into merits of the case, this writ petition is disposed of with a direction to the petitioner to approach the chairman cum MD IDCO OP number 2 with a detailed representation regarding his grievance, who shall look into the same and take appropriate action in accordance with law. Writ petition is disposed of. Thereafter, my lord, under Annexure 17, page 76, on 22/11/2014, my lord, I made representation before CMD OP number 2 IDCO. But without disposing that representation, my lord, your lordship, without disposing that representation, my lord, this present impugn order has been passed. My lord, cancelling.
Madam, that is what you're supposed to read. You're reading everything else. Come to page 21.
Your lordship.
Page 20. Page 21.
Page 21, your lordship. Your lordship. May I? Your lordship, with reference to the subject and letter stated above, it is to be intimated that IDCO had allotted the said number A by 41 and 42, measuring an area of 91 decimal industrial estate, Khapuria Cutter, White's letter number 19/3/1982, dated 8/8/1982, including regularization of excess land of 35 decimal for establishment of pharmaceutical unit. You have executed lease agreement with IDCO by deed number 27/2005. You have grossly violated the terms and conditions of the above lease agreement by entering into an agreement on dated 21/2/2007 with an outsider, namely Rahul Jain, presently OP number 7. Clandestinely without prior permission of IDCO.
Stop there. Is the statement correct or wrong?
Execution of agreement is correct.
With or without prior permission?
My lord, this execution of agreement is correct, but that agreement does not create accrued right in favor
Forget about whether it creates right in favor of OP number 7. Did you take permission of IDCO to enter into this agreement?
My lord, clause 5 is there. Your lordship may kindly see clause 5. What says the clause 5? That is relevant. Annexure 7, clause 5. Your lordship. Page 38, your lordship.
Read it, please.
Your lordship. The clause 5, the lessee shall not assign or transfer or encumber or part with interest either in part or in whole in any manner whatsoever without prior approval of the lessor. It shall be open to the lessor to grant or refuse approval or impose any condition if it consider necessity any suitable.
So what is your submission?
My lord, in reply to that, my lord, immediately after execution of agreement.
After execution, it says before.
But this is not amount to transfer, my lord.
No. What do you mean?
My lord,
this is new concept.
My lord,
not only transfer, the man has already occupied it also.
Yes, because I have been occupying. Yes, he has taken all money.
You're 7. You're the great friend of this petitioner.
Then right. Your lordship.
Word prior is very important.
Nothing's there in this case.
Then your lordship.
You managed to drag it on for so many years. I'm surprised.
Your lordship, agreement 21/2.
In fact, she comes, gets a stay, he benefits. Status quo benefits. Huh? No, this man is outside anyway. He's in the first. He's happy enjoying it because of the stay order here. So IDCO cannot touch him.
In fact,
It's actually, I think it's a collusion petition.
No, sir. In fact, she has taken the amount. She has taken the amount, delivered me position, everything.
Yeah.
And I have been running my units, minutes. And I have been position.
Let me submit. Then thereafter you will.
Touch any of them.
Till police completes.
Your Lordship, may I take your Lordship to page 55 that immediately after execution of agreement, I have applied for withdrawal of that. That was accepted by
it will not rescue you at all, madam.
That was
You have to take prior permission. So any number of letters you wrote after the lease agreement with this man, no help.
That was accepted, approved by IDCO. My withdrawal was approved. Your Lordship, kindly say page 55. Only for a moment.
All right.
Your Lordship. With page 55, annexure 9. Your Lordship. With reference to your number dated 3/8/2009, because on 3/8/2009, I applied for withdrawal. On the subject cited above, it is to intimate that your proposal for mutual transfer of the said number A by 41, but wrongly it has mentioned as A by 42, but agreement in respect of A by 41 in favor of Preeti Industries, OP number 7, and Hema Enterprise respectively were processed, but could not be decided due to non-compliance of required formalities because he did not cooperate. Your present request by aforementioned letter for dropping the mutual transfer proposal has been considered and accepted.
When did you enter into the agreement, madam? Give us a date.
Your Lordship.
Which date did you have the lease agreement with this gentleman?
Yes, sir. Agreement was on 22. Your Lordship. 22/10/2007.
And when did you make the request for withdrawal?
22/10/2007 agreement, then 3/8/2009. I have
2 years. So it clearly shows what you're up to.
Because my lord, I am admitting that after 2 years I have applied because my lord, some documentation should be there with the IDCO due to non-cooperation of OP number 7 that could not be
He's a
materialized.
stranger. That OP number 7 is a total stranger.
Then your lordship, that one thing that when this honorable court has already directed.
To pay this person a lot, got into the property. He's the one running industry now.
Yes, sir.
Prime property.
Under Annexure 17, my representation is pending in pursuant direction of this honorable court that has been not been disposed of.
Anyway, you've enjoyed a lot.
They have not taken a decision.
Many rounds. You've gone round and round.
They have not taken a decision till the impine order is passed.
All right. Anything else? All right. This is the second round of litigation at the instance of the present petitioner, who's aggrieved by the purported cancellation of the allotment of a plot of 2 plots, A by 41 and A1 by 42.
May I pray one thing, my lord?
A by 41 and A by 42.
Your lordship, sorry, my lord. May I pray one thing? My lord, as per IDCO Act, that the appeal provision is there. May I take a chance to file appeal, my lord?
No way. Measuring an area of AC 0.091 in industrial estate, Khapuria, Cuttack. Which had been allotted to it for establishment of a pharmaceutical unit. Paragraph, and a lease agreement was entered into by the petitioner with IDCO in respect of the above sheds on 2/7/2005. Paragraph. In the first round, when the paragraph. The case of IDCO is that without prior permission of IDCO, the petitioner entered into a lease agreement in respect of shed number A by 41 on 21/2/2007 with Messrs. Preeti Industries, bracket opposite party number 7. And therefore, the petitioner had violated the terms and conditions of the lease granted in its favor by the agreement dated 2/7/2005.
Agreement in respect of A by 41 only.
Full stop.
One plot. Annexure 8.
Who started occupying the shed A by 41 and started operating a factory therein. Full stop. The petitioner, after waiting for 2 years, wrote to ITCO seeking withdrawal of the application made to ratify the petitioners entering into a sublease agreement with opposite party number 7. Full stop. ITCO permitted withdrawal of the said application. Full stop. Meanwhile, FIR was filed by the petitioner with the police against opposite party number 7. Full stop. Agreed by the inaction of ITCO in seeking to evict opposite party number 7. Writ petition civil 13284 of 2013 was filed in this court by petition number 2. Full stop. That petition was disposed of by this court by an order dated 15/4/2014, permitting the petitioner to approach the chairman cum MD ITCO with a representation. Full stop. Paragraph. The petitioners then filed such a representation on 22/11/2014. Full stop. On that representation, following order was passed. No, the ITCO communicated its decision to the petitioner and opposite party number 7 by its letter dated 19/10/2015, cancelling the allotment of shed number A by 41 and 42. Full stop. Agreed by the said decision, the present petition has been filed. Paragraph. While issuing notice in the present petition on 24/12/2015, this court directed status quo to be maintained. Full stop. That stay order is continued till now. Paragraph. Counsel for the petitioner contended that although the petitioner did enter into an agreement on 21/2/2007 with opposite party number 7 in respect of the shed A by 41, and admittedly without prior permission of ITCO, the petitioner did apply to ITCO for a formal approval thereafter. Full stop. Once it was realized by the petitioner that opposite party number 7 had forcibly occupied shed number A by 41, the petitioner wrote to ITCO on 3/8/2009, withdrawing its proposal for transferring shed number A by 41 in favor of opposite party number 7. Full stop. Counsel referred to ITCO's letter dated 5/8/2009, accepting that proposal. Full stop. According to the counsel of the petitioner, ITCO has failed to deal with the request of the petitioner for eviction of opposite party number 7 and instead has erroneously cancelled the allotment in favor of the petitioner. Paragraph. The fact remains, the above submissions have been considered. Full stop. The fact remains that the clause in the lease deed executed between ITCO and the petitioner on 27/2/2005 contains a clear prohibition on the petitioner assigning or transferring or encumbering or parting with its interest either in part or in whole or in any manner whatsoever in respect of the property in question, open quotation, without the prior approval of the lessor. Full stop. Entering into the agreement dated 21st February 2007 with opposite party number 7, proposing to sell shed number A by 41, was clearly in violation of that clause, as the petitioner was parting with its right and interest in the property and was doing so without prior permission of ITCO. Full stop. There was therefore a clear breach of the terms and conditions of the allotment of the plot in favor of the petitioner. Paragraph. Irrespective of opposite party number 7 occupying the plot in question without the authority of law, the fact remains that the petitioner breached the terms of allotment made in its favor by ITCO. Full stop. Consequently, the court is unable to find any error having been committed by ITCO in rejecting the petitioner's representation and cancelling the allotment made in its favor of shed number A by 41 and 42 without full stop. There is therefore no merit in the present petition and it is dismissed as such. The interim order is vacated.
Connected cases.
Connected 169 in view of the order passed by the court.
Connected matter is different, Your Lordship. 11069/2012. Your Lordship, it is against the
I am the prisoner in this case, Mars. In that that is against the cancellation of my certificate, registration certificate under the Fact Act, without conducting any inquiry, my certificate has been cancelled without following the due procedure, natural justice and due procedure of law manners. But that is violative of 31 of the Odisha Value Act.
That bad registration is no longer valid, sir, now?
No, it is not wrong, but it was there.
There's no interim order, nothing, sir.
No.
You see, due to subsequent developments, is the other one, 11069 of 2012. Due to subsequent developments, when there is a new GST regime requiring the petitioner to register thereunder, there is no cause of action surviving as far as the present petition is concerned. It is dismissed as such.
May I pray one thing? I may approach for the trace registration.
For what registration?
It was rejected. I am operating. Registration has been rejected. I can, due to these this pendency of this case, it was not. I was not. I have not approached the authorities.
No, there's nothing. There's no interim order here, sir. Mere pendency. This petition never prevented you from getting registration in the GST.
Statutory formalities you have to comply.
Yes. All right.
170.
None appears dismissed. Oh, he's here. All right.
But I'm challenging them on Annexure 9, page 26. With the supplemental Bonai has directed the petitioner to accept the monetary compensation without the grant of land lease. You know, kindly count
that Jawan lease is over, yes, sir. Now. That whole policy is over now.
As we have filed a counter affidavit.
Yeah. You see, with the Jawan lease policy having come to an end, the petitioner cannot possibly be issued the granted the relief as prayed for in the present petition. However, the dismissal of the present petition will not prevent the petitioner from approaching the state authorities for compensation in terms of the extant policy in accordance with law. The petition is accordingly dismissed to the above directions. Right.